was to come into force early this year, but due to this pandemic situation, they have postponed it, and that will come into effect only end of this year. Once this is effective, all the European countries will come under the European Aviation Safety Agency regulation, and the drone registration will have to abide with their regulation. They follow a certification requirement on the basis of a standardized risk assessment. So their regulation is not on the basis of weight, but on the basis of risk. Therefore, that is slightly different because the device that is low in weight also may have a high risk element. Similarly, a high weighted device may have a low risk element. So therefore, it is time for us to consider that the laws in EU is taken into consideration for the purpose of further amendments. In my finding, I am coming to the theme of the conference, Law at Crossroads. So we have two paths to follow. One, to go in the traditional way with all the existing systems without going forward. So we are stagnated there, not moving from there. We have to think whether we are to take the digital technology, information technology law and go forward. In that sense, I recommend that the drone be used for commercialization as well in our country in future, because that's not permitted nowadays, right? So the promoting drones is something that I recommend, but with appropriate checks, with concern of all the areas of law that I have mentioned. So in the next symposium, if this pandemic situation continues, law faculty may be able to hire Uber or Pick Me. They might have a drone device at that time in a year to come to deliver pizzas to all the panelists at their home. Thank you.
Thank you, Professor. Thank you, Professor, for the wonderful presentation. And we have a small problem with one of our panelists. He hasn't joined yet. So, can I have 2 minutes to sort out that? No. Sir Jayanta Fernando couldn't join with us. He has joined in the different session due to technical issue. I will take up for the panel discussion.
Shamila,
Yeah.
could you
Yes.
please resend the link, because he is ended up in the private law department with Mr. Alagaratnam. So I think
Yes.
we need to send a fresh request to him.
At this moment, we can't do that because he has already joined in our session.
We can close that and join this session, I
Rejoin,
suppose.
madam. Otherwise, he will.
Yeah. He is again joining. We'll see whether he can join with us. Yeah. Yes. Can you call him?
We can start with the other panelist, Shamila.
Okay. යටම link එක නෙමෙයි උඩ තියෙන යටම එකට කලින් එක.
Okay, madam. Then we will carry on our discussion, panel discussion. I open the floor for panelists. for your comments and further discussion about the Professor Segaraja Singham's topic on promoting artificial intelligence and study of the regulation of unarmed flying object known as drone. Panelists, over to you.
මේ brochure එකට පල්ලෙහා තියෙන link එකේ join කියලා button එකක් තියෙන්නේ. brochure එකට පල්ලෙහාම තියෙන එකේ.
Swaminathan sir, can you hear?
Yeah, I can hear.
Yes, sir.
Professor Segaraja Singham's presentation is very timely and thought-provoking, and she has very clearly gone into the details of the Sri Lankan and the European Community law. Because Sri Lankan law, as she has correctly pointed out, has only a limited number of statutes at this moment: the Civil Aviation Act and Civil Aviation Authorities Act. She has also referred to the European EU law. Of course, as she pointed out by Professor Grajasingam, several areas of law are involved in this. And I think in the new, at least in the next year or maybe a separate paper, I think maybe prepared. What are the areas each one of these laws that require attention by the legislature, so that the use of drones in Sri Lanka would be controlled and properly regulated? I think particularly in the areas of law, privacy law, and maybe intellectual property law, there could be a fair amount of problems, and of course, to a lesser degree in probably in environmental law. Corporate law, I really don't know, but I think there is another paper that is being presented this morning on artificial intelligence and corporate governance. So probably we'll learn something about that when we listen to that presentation. So I think it's very thought-provoking, but at the same time, I think further research should be done to show in what areas of law we should make amendments, and so that the legislature will be able to enact such laws so that the use of drones in Sri Lanka would be better controlled and regulated. Those are my initial observations.
Thank you, sir.
Yeah. Sir, Sunila Pedak.
Yes, thank you very much, Professor Shanti, because it's very useful and this developing area, because the technology is developing, that we have to use this technology, science and technology, to maximum for the benefit of the society. That your presentation is the part of that. Recently, the Sri Lanka Army also set up the separate regiment for that purpose, the drone regiment.
Yes, sir.
But of course, that we can discuss these drones mainly under the big data, rather than into artificial intelligence. Sometimes we can use the drones under artificial intelligence as well. But my feeling is, if you can discuss the drones, movement of drones, the collection of data under big data, it is easy to explain the situation. As Professor Shanti explained, there are lots of benefits we can get, especially for environment purpose of the before this COVID pandemic, that so controlling mechanism purposes. But as you said, the serious issue is what is the position after collecting this data information? What is the rights of data subject? Up to date, that we have not adopted or accepted data protection laws, but considering various statutes and acts, especially ICCPR Act, of course, there are some provisions, but my personal feeling is it not enough. So in the future, that we can get lots of experience from GDRP, that General Data Protection Regulation in European Union, That is how they control this situation and the mechanism. Getting this experience, we can have the nice data protection law in future, since Mr. Jayant Fernando also joined us, that he will take these initiatives, I hope, right? But anyway, that I personally am not happy with some movements going on, because the last 12 years we are discussing about this data protection. This is high time, as you said, Professor Shanti, because mainly that we have to think about the damages to successful claimant who claim that that someone has violated after collecting data, and the compensation against pecuniary and non-pecuniary losses to the victim or the aggrieved party. And we have to develop injunction as a preventive measures against the wrongdoer who collects data illegally. So likewise, these are the main areas. Of course, after during this discussion, I will make my other contribution.
Thank you very much, panelists. Mr. Jayant Fernando has joined now. Welcome.
Yeah. Thank you, Shamil. I had a bit of a difficulty on the technical side. I'm just out of Colombo. It's a pleasure to be able to join this session. I'm sorry, Professor Shanti, I couldn't fully enjoy your very colorful presentation. Nevertheless, I just want to commend Professor Shanti for the very insightful paper that has been presented this morning. I had the occasion to briefly look at the paper that was circulated some time ago this morning through Shamila's best efforts. One important point, in addition to the significance of data protection privacy, that is a looming issue in the context of the use of drones. We all know that there is a significant commercial benefit that is accruing to countries in the context of COVID. We know that in the case of Amazon, in the case of many other global supply chain providers, given the fact that the human contact between individuals is becoming minimal, we have a situation where the use of drones for supply chain delivery or logistic management is becoming a moot point of discussion at a global level, and large e-commerce players like Amazon is using them effectively. So in that wider context, something we might like to consider is the application of some of the international sale of goods law provisions, as well as UN Electronic Communications UN Electronic Communications Convention provisions to see whether contract formation can be done digitally by technological means to ensure that the commercial law benefit, the benefit to the consumer can be ensured in the context of the supply chain and logistic chain management that drones have provided in recent times. That's one aspect that I thought I'd like to emphasize. So we have now had a situation where contract formation is happening through automated means, thanks to the provision of the UN Electronic Communications Convention that is reflected even in our Electronic Transactions Amendment Act number 25 of 2017, which refers to automated contracts. So in that context, whether the supply chain activities or logistic management activities can be ensured more effectively using drones is a value addition that can be considered by Professor Shanti if she wants to think of that aspect as well, right? The other last point I want to add is that the use of drones, I know the subject here is specifically the study of the regulation of unmanned flying objects known as drones in the context of promoting artificial intelligence. I understand the pitch here. Nevertheless, in the context of the global norms, especially between superpowers in the present day context, and use of drones, unmanned flying objects for military purposes, there is an international discussion going on right now about the use of drones in conflict and conflict management resolution, and the application of even the international humanitarian laws in the context of the use of drones in conflict, right? So that is an entire subject matter that is being discussed in that fora. If you are interested in obtaining more details about it, I'll be pleased to provide more information in relation to that whole separate pillar at the appropriate moment in time. So these are my comments. Thank you.
Thank you very much.
Okay. Thank you, sir. Thank you very much. And any participant would like to take the floor for any questions or comments? Yes, then I will move on to the next presenter. Our next presenter, Dr. Sampath Punchiheva, Senior Lecturer, Department of Commercial Law. Dr. Punchiheva will analyze the key provisions of Bayh-Dole Act and suggest to what extent the Sri Lankan policymakers can emulate the successful lesson from Bayh-Dole legislation to foster an innovation ecosystem in Sri Lankan universities. Dr. Punchiheva, over to you.
Shamla,
Professor,
please,
Professor, can you close your window, please? Yeah, thank you.
Shamla, can you see my presentation? Shamla?
No. You have to share it.
Can now?
Yes.
Yeah, we can see it now.
Yeah.
Right. Distinguished members of the panel, experts, Madam Dean, and other colleagues of the department. So today I'm going to enlighten you based on a research that I have conducted for this symposium that is entitled Promoting Academic Entrepreneurship in Sri Lanka, Lessons from the US Bayh-Dole Act. So my presentation is a very timely initiation because the countries and the university system is experiencing many calls from the national and international level to embrace research in order to find viable solution to COVID-19 related areas. So I have already we have the research conducted by University of Colombo in this area. So it is what we branded is the academic entrepreneurship, which is a timely and national priority at the moment. So I wanted to shed some light on this because in Sri Lanka there is no robust, or rather comprehensive legal framework to address the university industry partnership model right now. So this research, therefore, is an effort to enlighten you all and also the policymakers on the need. So my presentation is arranged as for the agenda given on the slide. So I start with the introduction. Background I have already set out. Research problem, objectives, methodology, results, findings. Then a bit of dealing with the US Bayh-Dole Act, and then Sri Lankan legal landscape, as the time permits, I would enlighten you, shed light on recommendations plus concluding thoughts. So new research, university research, new model for university research translation. It is this idea has been across the world for at least last 4 decades. So undertaking research enterprise. So it bit sounds on business arena, but it is university research enterprise. So there is a paradigm shift in the world on this technology transfer landscape. So industry academic partnership model for promoting university research and commercialization has attracted increasing global attention in recent years. If you see Stanford, MIT, Harvard's, this Moderna vaccine, and also other corona-related medicines now being channeled through university-private partnership. So in all these research endeavors attributed to the US Bayh-Dole Act. So if you see the many countries, the Bayh-Dole US Bayh-Dole lead followed in many countries right now. Germany, which was earlier professor's privilege, now looking at university ownership model. So is Japan, Brazil, China, Indonesia, Malaysia, Singapore, South Africa recently, and Taiwan have initiated Bayh-Dole-like legislation in their respective jurisdictions. Therefore, in recent in 2002, Economist has introduced Bayh-Dole Act, possibly the most inspired piece of legislation to be enacted in the US over past half a century. So its success being viewed through economic terms, economic development, and university startups. So background to in terms of dealing with this research, my research, the background is that Sri Lankan University umbrella organization UGC has introduced UBL Circular 2016, number 10 of 2016, in embracing the international norm, so-called academic entrepreneurship. So in going forward, this circular is a small step in the right direction, but not without its critiques. That is I stress there because it is very important. And then if I view through the lens of the research problem, even though Sri Lanka has introduced UBL circular, it does not create a viable solution right now. So UBL circular, as implemented, has encountered a set of challenges and legal issues. Therefore, it is imperative, very necessary for us to examine the provisions of the Bayh-Dole Act in order to emulate lessons and experience from emerging, more sophisticated jurisdictions. So, objective is to analyze key provisions of the Bayh-Dole Act and to recommend Sri Lankan policymakers the way forward in amending the Universities Act. So, in terms of methodology, this research was conducted by consulting multiple sources of information on Bayh-Dole Act, legal literature, very little, case law jurisprudence, and specialized articles and previous studies. And this research follows black letter approach viewed through the qualitative research paradigm with the assistance of revelational epistemology. In terms of the results, intellectual property rights are the oil of this 21st century, and we are very much criticized far too long that we are monopolies of knowledge and sitting on an ivory tower. Universities, in fact, are gold mine of knowledge, and universities produce original research, create useful technology, and it has potential of stimulating economic development. To bring university academia from ivory towers to innovation powerhouses, we need a legislation like Bayh-Dole Act. So university research technology process, I don't have much time to go through. It is starting with invention disclosure, assessment, then protection, marketing, licensing, and bringing revenue stream to the university. So this is now I turn to the Bayh-Dole Act, which was earlier introduced. It was named as the most successful piece of legislation in the US. So it is, this particular piece of legislation is, the proper name is, as you know, its longer name is Patent and Trademark Amendment Act 1980. And it deals with intellectual property rights stemming from state funds. This act allows universities to retain title to inventions made as a result of publicly funded research. So this Bayh-Dole Act has very positive features in its legal anatomy, provisional anatomy. So it has favored priority being given to the small businesses in the US. And there is a balancing device called margin rights, where compelling reasons like health emergencies triggered needs can be reconciled by using margin right in the US. So even though these positive aspects being also measured by way of innovation, to 5.9 million jobs being generated, and US dollar 1.7 trillion economic impact, and Bayh-Dole has given birth to 11,000 startup companies in the US, and you know we are also today benefited by this. This forum is this hybrid forum is benefited by Google, Yahoo, and other technological giants emanated from US university startups. So so having had this thought, I would like to also enlighten you on the critiques on this act. So most vehement critique in this is that the act is this act distorts research priorities and redirecting resources away from basic research to more commercially viable lines of inquiry. So in terms of swelling ranks of critics, one has to be mindful of corporate research. Universities are becoming corporate research laboratories. So is that research decisions are now being based on possible profits, not the inherent value of knowledge. That is, we are just moving away from the core mission of the university, as critique already charged on this piece of legislation. Nevertheless, the most successful lessons are teaching, giving us adequate benefits in this technology transfer landscape. So in turning to Sri Lanka, our Universities Act 1978 does not have any specific mention about the university research commercialization. So we have to rely on IP Act. IP Act has a provision that in many areas, if the work is done in furtherance of the contract of employment, the result will accrue to the employer, that is the university. Nevertheless, university, we should not allow university, even though we don't have proper laws, adequate provisions, university innovation should not lie idle, accumulating, thus not benefiting the taxpayers. And I think my personal belief is, my argument is that universities are state-funded institutions, and the taxpayers' money should be spent, and there should be benefits to the average taxpayer on the corridor of the street. So everybody should be benefited. So remedy in this situation, university to remedy this issue, university UGC umbrella organization introduced Common Circular, as I mentioned earlier, 2016. So impact is, at right now, universities in Sri Lanka, 15 universities and 6 higher education institutions have crafted, established university business linkages cells called TT offices, and they have crafted university IP policies. All IP rights are governed by university IP policy right now, and our university is blessed with our university IP policy. But of course, it needs refinements and constant changes right now, because of, as the director, I know there are many issues to address. So, in terms of the conclusion, I would like to emphasize the concept of technology transfer embraces that technology transfer of research results from universities to commercial marketable products for the benefits of people. And taxpayers of the country and public in the country should be benefited by this university, by our university research and innovation. So there should be, in this regard, UBL Circular 2016 is not adequate. And with the empirical evidence that I have obtained from 15 universities, they are facing numerous challenges in the implementation of the circular. So forward thinking, BEDOL equivalent legislation is necessary to inculcate academic entrepreneurship in this country. So in moving forward, many lessons that can be learned from the US BEDOL Act. Most desirably, University Act has to be amended, and it is imperative for the policymakers to foresee insertion of new provisions to deal with new scenarios and emerging trends in the world of technology transfer. This model is based on triple helix model, which would reinforce the university core mission. In the interest of time, I would not go into that. This triple helix model in the US is emphasizing the government, public funded research, and involvement of academia, and facilitated by risk takers called industry. So combination of three domains will create a lot of benefits to the country, and public benefit will be derived from this. And this is, in last words, I would say this is a small step in the right direction. However, we have just started, and the benefits and the research emphasis of the university bring us to that direction. With that, I conclude my presentation. I thank you, everybody, for your giving me a patient hearing. Thank you so much.
Thank you, Dr. Punchiheva, for your excellent presentation. Now I open the floor for our panelists for further discussion. And also, I'll kindly remind our participants, if you have any questions or comments, please use the raise your hand features in the app so we can take up those. Thank you. Panelists, over to you.
Stop share.
Stop. Yeah, but Sampath sir, can you?
Yes.
Yeah, your slides are still available. You can. Yes.
I will. Yeah. Stop.
Thank
okay.
you.
Go ahead.
Yes. Thank you.
Done.
Can I just request Dr. Punchiheva's views on this one or two matters or clarifications? Namely, now, this BEDOL Act in United States is really an amendment to the Patents Act, isn't it? As he said. So, do you think that an amendment to the Intellectual Property Act in Sri Lanka would be appropriate, or should it be a separate statute like the amendment to the UGC Act?
Sir, may I now intervene, or should I answer later? Shamila, should I respond to sir?
And
yes, you can.
Can I also couple it with another question? Now, I'm not sure whether there is a comparable legislation in the United Kingdom. Now, for instance, we all know that today that the University of Oxford, together with I think Zeneca, has produced this COVID-19 vaccination. Now, what is how is this situation tackled in the United Kingdom? Is there a similar act, or is it by ordinary patent legislation?
Sir, very pertinent, very appropriate questions. I hope this kind of questions from also the policymakers in this country. If I do get a chance, of course, we made representation to the minister. Nevertheless, sir, as to first question, this US Bayh-Dole Act is a unique piece of legislation to bring academic entrepreneurship, the culture of academic entrepreneurship to the universities. That is first thing. Second, Sri Lankan IP Act, sir, already we do have this provision that work for higher doctrine, and also in if the university employs us, and if we do this is except for copyright, other research can be accrued to the university by virtue of the IP Act. So third question, this IP Act, amendment to the IP Act does not make much difference here. What is required in this country is to introduce specific provisions into the Universities Act, which we have recommended the Sri Lanka Technology Transfers Association, for which I'm also in which I'm also a member, and now we have made representation because in the Universities Act is now having the amendments process. There will be a new act coming. It is now in the pipeline, and we have made representation that this academic norm, the academic entrepreneurship norm, to be embedded to the Universities Act in order to avoid any kind of difficulties. Third, as to the last question that sir raised, is that in the UK, it is called Lambert Toolkit. That is public-private partnership model, not the Bayh-Dole model, but they have borrowed heavily from the US model. But sir, it is in the UK, most universities are private owned. Therefore, the best top ones are also private owned. So therefore, not all government universities are involving in that endeavor. Therefore, the best is to UK model is called Lambert Toolkit model. In Europe, formerly it was professor's privilege. Professor's privilege based on publish or perish.
So that means as far as UK is concerned, there is no statute as such, isn't it?
So it is called Lambert. It's a policy guidelines by the Ministry of.
So it's not statute. There is no statute, but it's only guideline.
Guidelines issued by the Ministry of Education.
True. But isn't it true that even in the US, most of the leading universities are privately owned?
True, sir. Stanford and other places. But sir, US wanted, because government is giving huge amount of money to higher education institution, and then government own the IP of those things before to 1980. That's why there was a need to give the ownership to the universities.
Right. Okay. Thanks. Understood.
Okay. Excellent.
May I?
Thank
you very much, Dr. Punchewa, because this is a new concept. In fact, when we look at the situation in United States, it is very clear, as you explained, is government funded as the universities and the research institutions and other institutions, how they get the due protection. Especially, I would like to highlight two judgments relevant to that. One is Stanford versus Forge case, and the University of Rochester's case. In these two judgments, it's clearly explained what the relevancy and the importance of the act. So as you explained, it is very clear because this is a high time government-funded universities are available. In the meantime, now we have lots of private universities also in the country. This is high time to introduce this concept. And United Kingdom, yes, United Kingdom, of course, though they don't have this act because they have adopted this system. They are working under that. But anyway, this is the birth of this that law in the United States, because we can get lots of experience from that. One matter that I would like to suggest, even this is what Dr. Swaminathan also raised, if we can bring at least some provisions comes under the present Intellectual Property Act, it is be useful. Otherwise, it will be the completely different concept under University UGC Act or whatever it is. So if we can think about that, because we have to introduce this amendment. But my suggestion is, if we can bring at least that couple of provisions relevant to this under intellectual property. Thank you very much, Dr. Punchewa.
Yeah, so let me also add my comments on the paper submitted by Dr. Sampath Punchiheva. I think this is a very important moot point of discussion in the present day context. Can you all hear me?
Yes, yes.
Yes.
Yeah.
Yes.
Yeah. So what I want to emphasize is that, in my opinion, at this academic symposium of the Colombo University taking place today, I would consider this as a very this particular paper submitted by our good friend Sampath on promoting academic entrepreneurship in Sri Lanka to be of a very high, significant, contemporary benefit, given the fact that at this moment in time in the country, the need of the hour is to have a practical linkage between the academic community, the research that they are doing, with the practical policy development initiatives taken, spearheaded either by the government or by the private sector. And in that context, in the context of promoting public-private partnership, what we lack is the concept of academic entrepreneurship that is not embodied in the existing legal framework in Sri Lanka. And that is the reason why I really appreciate this paper, because of its significant practical value. Now, having said that, I want to emphasize that the UGC Commission Circular number 10 of 2016 is not adequate. I agree with that proposition. We need to work towards not only an amendment to the Universities Act, but perhaps a possible amendment to the Intellectual Property Act number 36 of 2003. I agree with Sunil in that context that we need to do perhaps a two-pronged approach if we are to fall in line with the Bayh-Dole Act of US. Because if you remember, the background to the entire legislative process that went in 1980, that set the stage for the universities to become quote unquote corporate research laboratories. No doubt there's criticism about it, but if you keep that criticism aside, it has resulted in a healthy output of job creation to practical, result-oriented, market-oriented development objectives. So in that context, doing amendment to the Universities Act coupled with an amendment to the Intellectual Property Act number 36 of 2003 to embody the features of the Bayh-Dole Act, going beyond the work for hire doctrine, and maybe bringing something in the line of the Lambert Partnership in UK, may be an approach to be considered. My proposal, having commented in that context, is to say that going forward, since Sri Lanka needs this concept included as a fundamental policy principle, we are already behind time. And given the fact that we don't have even a sufficient number of patent examiners in the country, there's a necessity to comprehensively amend the Intellectual Property Act and the Universities Act and resuscitate the ability that has been provided to public-private partnerships like SLINTech. Sri Lanka Institute for Nanotechnology is perhaps the only available public-private partnership where this model can be practically tested. So I would like Sampath to consider that aspect, the practical deployment of this paper as a policy initiative for the country to strengthen partnerships embodied in places like SLINTech, where we have just only a few patents that have gone through, and most of those patents have been international patents because we don't have a proper patent examination process. So if you want to make it a holistic paper, I would strongly advise the University of Colombo to submit this paper potentially to the Ministry of Technology, and if necessary, I can facilitate that process. Thank you.
So I am indebted to your wisdom, and I would definitely, this is a short paper, research paper, but I think this can be further enriched, enhanced, encapsulating the points Saminathan sir, Sunil sir, and Jayanta sir has nice, aptly pointed out.
And just in conclusion, would this Bayh-Dole Act also cover institutions like the TRI, Rubber Research Institute, and Coconut Research Institute, that sort of research, public research institutions, or is it only confined to universities?
Sir,
so there are also,
no,
there
sir,
are also this.
Yeah, in the introduction, the Act in the preamble is very sweeping, overarching, and it has public funded research institutions, sir. Then
so not confined to universities alone.
Universities are only one set of beneficiaries of.
Thank you.
Thank you, panelists, for the interactive discussion. Dr. Punchiheva, can you please click on your top of the screen, stop presentation button?
Okay, excellent. Right. Okay, stop presentation.
Thank you. Yeah, thank you so much.
Very welcome.
Okay. Since we don't have any questions from participant, I'll move on to the next presenter. Our next presenter is Dayanandi Sudagar, lecturer from Department of Commercial Law. We'll talk about corporate management in the age of artificial intelligence. Her discussion will touch key areas of corporate management, including artificial intelligence, boardrooms, corporate law, and directors. Let's find out what would be the suitable legal principles for corporate management that must be adapted to solve the challenge posed by artificial intelligence. Now we will listen to Ms. Sudagar's pre-recorded video. Yeah. Yes. No volume. Can you hear her presentation?
No, we can see it.
Okay.
Making. Corporates cannot avoid facing the issues raised by AI. The AI could support or even replace any human who involved research, title, corporate management in the age of artificial intelligence. Artificial intelligence is changing our lives in many important respects. The corporate realm is no exception. As a direct consequence, the board of the companies may soon undergo radical changes. World Economic Forum expects a corporate law will undergo to a fundamental change by 2025. AI will share the board and play an important role in corporate decision making. Corporates cannot avoid facing the issues raised by AI. The AI could support or even replace any human who involved closely with the corporate bodies. The presence of AI in boardrooms in any form raises a number of moral and legal issues. This is the outline of my research. The objective of this research is to explore the interplay between AI and corporate law and analyze how both can work together. The primary question that arises is whether the current corporate law of Sri Lanka is compatible with the challenge posed by AI, or do they need to be adapted? The study is qualitative in nature, which is based mostly on secondary data, while a few primary sources, including statutes, are utilized. The research limits its focus within the four corners of the provisions of Companies Act of Sri Lanka. AI is a stimulation of natural intelligence performed through algorithms. It takes all available data, store it to make decisions by comparing the data. AI has already been used in many fields such as medicine as well as legal practice. IBM's Watson for Oncology is an AI machine used in determining possible cancer treatments. Law Grease AI is a contract review platform assisted for non-disclosure agreements in a method more accurate than lawyers. In the year 2014, Hong Kong-based venture capital firm Deep Knowledge Venture introduced an algorithm called Vichal in its board of directors. It was believed that Vichal could analyze financial trends and understand the financial statement. However, it was argued Vichal could vote in investment decision but couldn't technically qualify as a director since it was not programmed to perform the duties of director. Corporations are the legal entities. In economic perspective, they are simply the vehicles for investment. In the legal perspective, it is a separate legal entity. The principal functions of the corporate law is to provide a legal form for the business enterprises. If the law did not provide such a form, corporate would not even be come into existence. The corporate law follows a number of different legal strategies to mitigate the traditional agency problem. Therefore, it must be noted any sort of new legal strategy should be introduced within the four corners of established principles of corporate law. AI in boardroom. AI helps to make decisions by using a large amount of data. AI contributes to make quick and accurate decisions. AI is mostly like to be employed when most complex decisions need to be taken within corporations. The core decision-making body of the corporation is the board, which is not only responsible for the daily management of the corporation, but also for the strategic business decision. Consequently, AI appears to be most likely to play a significant role in boardroom, and it could be employed to assist the directors to make complex decisions. In corporates, AI could be conceived in three forms. In the first, machines can execute certain tasks, but the decision rights remains with the human directors. The second type is a hybrid system. The human directors and machines share the decision rights. Third one is machines ultimately take over all decision rights and replace the human directors. The supporting task of AI in corporate management, there are two preliminary legal questions arises. First is whether the directors have the authority to delegate decision-making powers to AI. The next one is whether they might even be under an obligation to do so. To answer the first question, Section 186 of the Companies Act, which allows delegation of powers. The company can restrict such powers through its articles of association. The law refers human delegates. Clause 5.1, the Companies Regulation 2008 of UK provides that board of the company may delegate its power to any person. Thus, the issue of whether or not the delegation of power to AI is permitted is open for interpretation. According to a literal interpretation, assisted AI would be employed and decision rights would remain with the human directors. However, it is possible to justify a broader interpretation which allows delegation to machines for effective functioning of corporation. Even though the directors are entitled to delegate certain functions, the exercise of such powers does not absolve a director from the duty to supervise the delegated function. Specifically, Section 186, subsection 2 provides that board shall be responsible for the delegated power. It is suggested these provisions can be interpreted to make the board accountable for the errors caused by AI. To answer the second question, corporate law requires the directors to act on informed basis. The directors of duty of care, they can apply business judgment in good faith and diligence. To make such judgments, the directors are required to gather sufficient information. If AI has superior information processing capabilities, the duty to act on the informed basis may well evolve into the duty to obtain such predictions made by AI devices. However, as long as the use of AI is not widespread with respect of business decisions, it seems difficult to establish that AI who do not take advantages of such establish a director who does not take the advantages of such divisions are acting unreasonably. The next option would be the human directors replaced by the AI directors. There could be two possibilities: using AI to replace the entire board or appointing a number of different AI directors. This is the stage of autonomous AI, where whether the machines can themselves become the directors is the primary legal question. What is relevant here is the legal regime for the appointment of directors. Corporate law allows only persons can be a director. Whether it is only the natural persons or also legal persons, however, differs from jurisdiction to jurisdiction. It is settled under the Sri Lankan law that any natural person can be a director as long as he or she does not disqualify under Section 202 of the Act. The position under the UK law is at least one director must be a natural director. It prevents a non-human autonomous system to be a director. Therefore, it can be argued that if legal entities are allowed to serve as a director under the law of Sri Lanka, autonomous AI system would be able to make such a position if they are qualified as a legal entity. Therefore, it all depends on granting the legal personhood of AI. The suitability of legal framework for AI. The personhood of autonomous machine is the priority for policymakers. AI machines currently do not have any legal personality. Therefore, they cannot be subject to rights and duties, including corporate fiduciary duties. In modern corporate law, the lack of legal capacity of AI would lead to a number of legal issues, particularly in the breach of director's duty. The choice to resort to AI is not legitimate under the Sri Lankan law. The algorithms are directly referable to the company that uses them. The actions of algorithms are the company's actions. If Sri Lankan corporate law permits AI to be appointed as a director, an entire new set of questions will arise. Liability regimes of director would be largely ineffective. The legal rules on the conflict of interest would lose significance, and the breach of duty of loyalty would vanish. The specific rules on directors' behavior will effectively be transferred from the law into algorithmic courts. Therefore, the entire new enforcement mechanism would be required because control of algorithms requires a comprehensive technical knowledge. Conclude my presentation. For the time being, algorithm plays a merely supportive role. However, it is possible in near future AI will play a more active role within the board. Listed companies are subject to a stricter regime that stipulates standard of directorial competence. The use of inter-firm AIs under the Sri Lankan corporate law must be subject to the corporate governance principle. It can be argued that some of the fundamental corporate principles are likely to become redundant if AI makes the decision. The law must focus more on ex-ante control of algorithms instead of ex-post control of directorial behaviors. Therefore, the development of suitable legal strategies for AI and robot directors will therefore become a crucial challenge for the future corporate law. Thank you very much.
Excellent, Ms. Sudhagar, and thank you for your well-prepared video presentation. Now we will listen to our panelists for their expert thoughts about your presentation. Panelists, over to you.
May I make a few comments? With regard to the corporate governance and AI, I think as Ms. Sudhagar has correctly pointed out, our statute law contains, at least it has codified basically the director's duties, and it will be difficult, of course, for a machine or AI to perform those duties. Of course, even today, I do not, is there any bar for directors to be to resort to AI for the purpose of assistance? I don't think there is any bar for that, isn't it? The directors could yet get their assistance, whatever assistance they require from AI technology, but the decision remains theirs. So it is like delegating it. Now, I think what Companies Act specifically provides, you can ask experts' opinions, you can obtain and such opinion, act on that opinion, provided you do it bona fide. By the ultimate, even if you delegate the function, the responsibility and the duty remains still with the directors. So as you pointed out correctly, there are three possible ways of doing it. The first is the assisted model. Assisted model probably will work even today, but of course the director will take responsibility for the decision, and the fact that you're done in good faith would probably be a mitigating circumstances if there has been no gross negligence or any other irrelevant factors. But I just would like to ask one clarification. Now, this must have been, I think you would have, there would have been other views expressed by various writers in the Commonwealth on this matter, which you may have referred to while preparing your papers. And what has been the general trend or the consensus of the way I established writers on corporate law with regard to AI and boardrooms? Have they expressed any view, or is it still a new area?
Yes, doctor. I have researched, according to my research, there are papers in which in many jurisdictions, they are just using this AI to assist their decision. Yeah, but so the personhood, that still we have the issue with regard to the personhood. Yeah. Replacing is the issue still we have. And have they expressed any views on that? Replacing, it depends on the policy making. If we can give a legal personhood for AI, then it can be, the problem can be solved. Otherwise, we can't admit the AI directors into the board. That is not possible like in other fields. Yeah, that is true. But Sri Lanka's position has been, I think, the old law. Yeah. The earlier law, 1940, the earlier law did permit corporations to be directors. But now the new law does not, because specifically says it should be a natural person, isn't it? Yeah. I think that Companies Act today says it should be a natural person. Yeah, we can't interpret it. Yeah. Thank you.
Thank you very much, Mrs. Sudhagar. Thank you for the new thinking. First of all, the artificial intelligence, of course, we can use this artificial intelligence as additional brain to the human brain. So artificially work, so we can get the assistance. And you quoted it as section 186 2, yeah, specifically it says how it delegates and the responsibility of the directors. Especially that when you take this 186 to BC, the board has failed to monitor by means of reasonable method properly used. Now, that's the check and balance. Finally, that responsibility comes to the director. So they delegate, they can take the advantage of artificial intelligence, like when you take the iPhone, iPad, we have that facility of Siri. Now, we can't totally depend on Siri because through Siri, we can get some assistance and Netflix like that. So anyway, ultimately, that my view is, I hope that you will include this also to your presentation in future. Basically, most of the countries control this AI behavior and activities on tort of negligence. Under law of torts, of course, they successfully they control this mechanism. Finally, what the responsibility of the creator or the person who made the robot, especially comes under robotics, so that we can add to this sector, and of course, this for the interpretation, the new interpretation in the future. So thank you very much for new thinking. This will be really useful in future.
Let me also add a few comments on this excellent paper submitted by Ms. Sudhakar. I also commend you for this unique research exercise, which I think is another interesting area requiring a lot of consideration by policymakers. I agree with Mr. Swaminathan's view that at this moment in time, there's nothing to prevent AI playing the role of assisting the directors. However, in the context of a hybrid model or a replacement scenario, there may be challenges under the various legal statutory provision, not only in Sri Lanka, but in a lot of other countries. The only additional point I just want to emphasize is that AI plays a unique role even at present in large enterprises, even in Sri Lanka, especially in the capital markets, investment banking ecosystem, where the financial analysis, data analysis in terms of millions of volumes of transactions taking place, it is impossible for human beings to do data analytics, do results-based monitoring kind of activity. So in that context, we have seen AI tools being already used. So it might be useful if you want to further elaborate on existing practices, if you need assistance to get details of existing practices currently taking place in Sri Lanka, India, in Malaysia, Singapore, Australia kind of jurisdictions. I'll be happy to provide you with linkages on that in that area. And having said that, I think the duty of care imposed on the directors does not get vitiated purely because they make a AI-based decision making. One interesting twist to this whole discussion, if you may like to consider that for a future expansion of your research, is if one were to use AI, at least in the context of a hybrid scenario, how it can be done in the context of satisfying the fit and proper test that corporate governance criteria brings in the context of banking sector, capital market sector. You know, the banking regulator, SEC, both have got stringent rules governing this area. How those kind of rules can be satisfied, whether those rules can be enhanced by using AI as a hybrid formula to perform the functions to support the work of a director and to ensure that their delegated functions through management under the provisions of the Companies Act are carried more effectively. So those are some thoughts I would like you to consider in future. But having said that, I once again would like to join the other panelists by echoing their sentiments by saying that this is an excellent paper and another interesting policy position that can be useful for decision makers in this country. Thank you.
Thank you so much for the fruitful comments. I will incorporate all in my future research. Thank you so much.
Thank you, panelists. I hope Ms. Sudagar will take note on all important points from our panelists to develop a final paper. Thank you. Thank you very much. Now I call upon our next presenter, Dr. Sumana Dasa, Senior Lecturer. Yes,
Shanti has a question.
Oh, I'm sorry. I didn't. I thought,
Shanti
yes,
has a
usual,
question,
no
yeah.
questions. Yes, thank you. Thank you. I will take up.
Congratulations,
Yeah,
Diana. Innovative way of thinking. That's what I always encourage the juniors to do. Don't go by the traditional law, think something new. Now, what I'm asking is now all this AI or your algorithm or whatever is a program one. No, you feed the data and that will support you to give you a result. So can it be used to eliminate fraud? Now in companies, that's a major issue, no, especially in Sri Lanka, no transparency, there is a sudden collapse and we don't know what has happened. So do you recommend that if AI is used in boardroom, that will eliminate fraud or the other way about?
Madam, thank you for the question, madam. I think it's possible, madam, but it's all depends on the coding system and all. So first we have to analyze the issues, actual issues, and we have to formulate the policies and the solution and all. Then we have to give the proper knowledge to the developers, that persons who are like making the coding and all. They have to make a proper system without any bugs. That there are so many bugs in the in every like systems and all. So we have to proper enlighten them. Then only it will be possible. Otherwise, we will face some sort of difficulties. Even we can't solve the problem in a effective manner. That will be a issue. So it all depends on the coding and all, and we need some high technological technology persons, the developers and all. Then they can do it with the proper knowledge. So we have we need both sides, that legal as well as technological side. Like people, they have to give the solutions according to my. I thought.
Thank you, Professor. Sorry, I didn't notice earlier. Now I call upon next presenter. I hope there is no more questions, right? Yes. Okay. Next presenter, Dr. Sumana Dasa, Senior Lecturer from Department of Private and Comparative Law, who will be speaking the role of the equitable doctrine of breach of confidence in protecting undisclosed information in Sri Lanka. That is another interesting topic we should analyze deeper, and Dr. Sumana Dasa's recorded video will be played now. Yes, you can.
Good morning, permission from the panelists and distinguished academics. My topic today is role of the
No, start from the beginning. No, can't hear. Yes, check the volume.
Discuss information in Sri Lanka. Good morning.
Yes, yes.
Good morning, permission from the panelists and distinguished academics. My topic today is role of the equitable doctrine of breach of confidence in protecting undisclosed information in Sri Lanka. So my focus is how to protect undisclosed information in Sri Lanka. And when we are talking about undisclosed information, if the three requirements of secrecy, commercial value, and taking reasonable steps to keep the secrecy are the main criteria in order to determine whether information is qualified to be protected as an undisclosed information. The law related to this is found in Sri Lanka from Article Section 160, subsection 6 of the IP Act, which is focused on protection of undisclosed information. This undisclosed information is commonly known as trade secrets in other jurisdictions. So, for example, Google PageRank and content moderation process of social media sites and KFC recipe and Coca-Cola formula, those are recognized as trade secrets. And even in Sri Lanka, there can be many trade secrets, but we don't know exactly to what extent trade secrets have been utilized by the businesses because of the secret nature. And also they're highly vulnerable because of the main criteria to be satisfied in order to track the protection is secrecy. So when it comes to the protection aspects, TRIPS agreement is the main international agreement with regard to the protection aspects of undisclosed information. It says the owners or the holders of the trade secrets or undisclosed information can protect their trade secrets from disclosing, acquiring, and using by the others in a manner contrary to honest commercial practices such as breach of contract, breach of confidence, and commercial espionage, etc., etc. And in Sri Lanka, we adopted TRIPS compliant legislation in 2003, and it says in Sri Lanka the protection aspect is an intersection of commercial espionage, breach of contract, and breach of confidence. So I noticed that the most popular two actions in Sri Lankan courts are breach of contracts and breach of confidence. So what's the objective of this paper is to explore to what extent Sri Lankan courts use breach of confidence as an action to protect undisclosed information in Sri Lanka. So this research is totally doctrinal, so that I have examined the existing and available primary and secondary legal resources with regard to the issue. So the origin of breach of confidence is totally equitable. That is dated back to 17th century. And this is based on the equitable notion that a person who has received information in confidence shall not take unfair advantage of it. So the modern recognition of this action is found in Foucault versus A. and Clark. Three requirements have been recognized by this case in order to establish a successful case on the breach of confidence. First one is necessary quality of confidence, and second one is imparting information in confidential circumstances, and the third one is detriment. Those are the three aspects to be satisfied. When we analyze the Sri Lankan law, courts are allowed to rely on breach of confidence action, as I mentioned previously, according to section 160, subsection 6 of the IP Act. And also, I noticed that there is no any reported cases in this regard, so that our focus should be on the cases of Commercial High Court. For this research, I've selected three cases mainly. First case is McCood versus Manoj Vikramatunga. So in this case, the court recognized the threefold criterion of the COCO case, and the main focus was the interim granting of interim injunction, and the information asked to be protected in this case is totally business information, for example, rates of commission and dealer network, etc. And in this case, it was held that the information does not have the necessary quality of confidence because those information already published in the newspaper and that is in public domain. And confidential circumstances was also there since the defendant was a leading general manager of a company, so that he had a privy to confidential information. And also in this case, clearly said that the detriment also not established. Therefore, court said that the prima facie case is not there and the balance of convenience is in favor of the defendant. Therefore, the court did not grant the interim injunction. The second case is linked natural products versus tropical herbs case. This was filed prior to the enactment of IP Act. In this case, the respondent company hired two ex-employees of Link Natural, which makes Samahan, and they had developed a new product called Swani, which is similar to Samahan. And in this case, also plaintiff, in spite of establishing the confidentiality of information of Samahan, the plaintiff attempted to utilize some chemical tests to establish the similarity between the Samahan and Sueni. So Justice Amarasekara held this in this case, court is unable to hold the case in favor of plaintiff, and court was not granted the since the court was not given the required information to make a decision on the secrecy of the information. And in John Keel's Holding versus Shanita Fernando case, the issue is whether an ex-employee of the plaintiff has misappropriated trade secrets relating to some price information and tourist routes, etc. And in this case as well, the Justice Amarasekara said that the plaintiff actually did not establish absolute and clear manner whether this alleged information is confidential or secret. So that the court did not grant the remedy asked by the plaintiff. So what we can observe from these cases or case analysis is that all of these cases were determined at the interim stages. So the court's main concern was that whether there's a prima facie case and also whether the balance of convenience in favor of the plaintiff. So that except the Manoj Vikramatunga Manoj Macfoot case, other cases did not go into the substantive details of the action of breach of confidence. And even in the Manoj Vikramatunga case, the main focus was whether to grant or not to grant interim injunction. So that, and also it is noted that the plaintiffs in a way are reluctant to establish the secrecy of the information, and because they are reluctant to reveal the secrecy of information and the information per se to the courts, because there is no statutory guarantee for the protection of secrecy of their information and during and after court proceedings. And also the courts did not go into the details to discuss the defenses applicable to action of breach of confidence, such as public interest defense. So that, however, courts are still allowed to go for the look at the developments made by the English courts, and also that is allowed by section 160 subsection 9 of the IP Act. Therefore, it is my belief that the courts are still can go into the look at the English law developments and absorb those things into the Sri Lankan law. Thank you very much.
Thank you, Dr. Darshana. Hope you are with us now.
Yes, Shamila.
Yes, thank you for the excellent video presentation. Now I open the floor for our panelists for their comments and discussions. Panelists, over to you. Yes.
May I just start the comments by, I think, congratulating Dr. Darshana on his excellent presentation, and might be just making one or two comments. I think Mr. Jayantha Fernando is also here. He probably would explain to us with the new Data Processing Act, which is I think now been discussed by various stakeholders, and I think which has probably been more or less finalized, has any impact on this matter relating to confidential information as contemplated or is referred to in section 160 of the Intellectual Property Act. That's one area I think which will be which probably would be of great interest at the moment. And secondly, the question of confidential information is both an IP matter and also a common law issue, as was pointed out, and it is discussed in all textbooks, both as in textbooks on tort as well as in intellectual property. And of course, English law has got a voluminous amount of case law decisions on confidential information. I think he has also referred to the leading cases of the Commercial High Court in Sri Lanka And just as a matter of interest, I believe Dr. Harsha Cabral has just published a new volume of called the Cabral's Intellectual Property Law Cases last month. And he has also included the commercial high court decisions. And I think all the 3 cases that was referred to by Dr. Darshana is fairly well, I mean, the judgments are fully set out to a great extent in that book. So that might assist those who want to read the cases more fully, because it's not easy to get commercial high court decisions and they are not reported. So it's probably the first attempt to report it. And I don't know whether there is any, whether Dr. Darshana has considered whether there is any basic similarity or difference between the English law of English common law of confidential information, and whether there is any law in what is the position in Roman Dutch law, whether there is such a delict, and is it are the ingredients the same or is it different? So those are just my initial thoughts.
Okay, thank you very much for your comments, sir, and the questions as well. And I'll certainly look at Dr. Harsha Cabral's new volume to see how he has analyzed the law related to undisclosed information. And as to my knowledge, correct me if I'm wrong, Jayanta sir, as to my knowledge, there is no any address of trade secrets in the Data Protection Act new bill. And secondly, sir, as you asked about the similarities or differences between English law, Roman Dutch law, and Sri Lankan law. And in Sri Lanka, actually in Roman Dutch law, some authors said some actions were there in the time of Roman law, not Roman Dutch law, in Roman law, to protect some secret information of employers from employees, that sort of things. But actually that has not been absorbed by the modern Roman Dutch law jurists. So that this area is wholly governed by English laws, actually English law governed area. So in UK, after the after EU Trade Secrets Directive in 2016, UK was obliged to harmonize their laws, and there was a chaos at that time because with the Brexit, they are still obliged to harmonize their laws or not. But however, in 2018, they made a regulation to slightly adjusting their laws with in view of the EU Trade Secrets Directive. So that, for example, they have given a statutory definition for undisclosed information. I mean, perhaps the main problem in UK is that they are not considering undisclosed information or trade secrets as a special category for the protection. But in general, they consider confidential information. So actually what they are protecting is confidence and trust in the relationship, not a trade secret or a confidential information itself. But this concept of trade secrets actually properly derived from USA, sir. USA. And also they influenced at the time of the TRIPS draft, at the time the drafting process of TRIPS. This USA delegation influenced the TRIPS drafters to have sort of provision similar to their provision at that time. That is their
trade secrets.
Their trade secrets, yes, sir. But however, there was a sort of problem with some country groups led by India, and finally they ended up with this provision, Article 39(2), and they relied on this unfair competition regime and that sort of things. Those are the comparative views that coming to my mind right now, sir.
Thank you.
Thank you, sir.
Can I quickly respond?
Yes,
quickly, yeah, just I just wanted to respond to some of the points you made,
yes,
and to that of Mr. Swaminathan. I actually really appreciate this paper, Dr. Darshana. This is also a very significantly important subject in the context of protecting information of value in the context of technology, especially digital products, and we all know the scope of copyright in protecting software and other digital substantive products and services has become an increasing challenge. We know the idea expression dichotomy in that context, and in view of the fact that copyright only protects expression format, increasingly companies are using the formula emanating from 160 subsection 6 or those derived from TRIPS Article 39.2, as you very clearly articulated, to protect material information broadly within the context of confidential information, in that context, right? By agreement, by entering into watertight agreements, NDAs, and so on and so forth. And then the question arises, how do you enforce those NDAs? So that is why I appreciated the case law you have cited. Unfortunately, we don't have sufficient cases in the appellate courts. We hope such cases will come out in the near future. I also encourage you to look at Dr. Harsha Kabral's digest, that's basically the point I wanted to emphasize is whether you might like to touch a little bit upon the digital products, services that are increasingly protected within the framework of the subject area that you covered in your paper is something that you might like to think about. Responding to your point very clearly stated in response to what Mr. Swaminathan asked about the scope and ambit of the data protection draft bill, the framework of the bill is to give a new suite of rights to citizens with regard to how their information and data is protected when they are collected by those entities empowered by law or by contractual law or other methods, right? So you have the concept of a controller, processor who collect information from the public in the course of their business activity, and the mode of protecting such information and the manner in which they could share that information with third parties is what is basically governed under the data protection bill. So I fully agree with you that law is a very special, specific sui generis law in that context, deriving some kind of precedent from international laws and principles emanating from OECD principles, the European Directive on Data Protection, and also the APAC privacy framework. So we are going in that direction to empower businesses and government agencies to protect data of individuals that are being collected. So while that law is in that direction, enhancing and protecting undisclosed information in the context of the knowledge economy in the digital age is a very important consideration. And I think expanding your paper along the lines you have articulated here and going beyond based on the input you just gave in response to our questions should be considered by policymakers in future. Thank you.
Thank you very much, sir.
Dr. Rashida, thank you very much, and I fully appreciate your attempt. In fact, your presentation is very relevant in future, especially considering the development of software industry and the technology. Now, when we take this section 160 of the Intellectual Property Act, it's a common section. It's relevant, sometimes it's relevant to copyright, patent, all other rights. This is a broad definition. Only that when we focus onto the trade secrets and violation of this confidential information, of course, that you have cited the COCO case, we can get some assistance since Dr. Swaminathan also raised about this English law, the concept, we can take some guidance from Fasenda Chicken Limited versus Fowler case and FSS Travels case. is very relevant to that English law.
Yes, sir.
Anyway, that as far as confidential information concerned, because they have different concept on the business know-how, and they are going different line, because it's covered under Section 160 of our Act.
Yes, sir.
So then we can, as you said, of course, we need more and more case law in future. Since I hope that Justice Obesekar, President of the Court of Appeal, also with us at the moment. I hope that in future there will be more and more that judgments come to the system. And as far as this data protection law is concerned, of course, this is a data protection is there for another purpose, to protect the personal data of a person. But when we come to this trade secret, of course, this comes under different concept, as Mr. Jayantha explained that. Even we can get some assistance from GDR PR even to cover that area. But this, of course, we have to develop in a different way, considering the speed of the development of that information technology law of the country. But what I can see is generally that Section 160 has covered in the sense, because what I can see is that we have legislature has given the framework. Either we have to bring some statutory laws, or we have to bring more amendments, or otherwise we have to develop that section, that area, based on case study. Either that we have to develop on that base, otherwise we have to get the guidance from mainly from United States, India, and United Kingdom. Thank you very much for your attempt. Actually, this is an area of the future intellectual property.
Thank you, sir.
Just a conclusion, I think it may be also relevant to consider the difference and similarities between the US law of trade secrets and the confidential information under the English common law.
Yes. Yes.
Thank you, panelists, for such an excellent analysis of Dr. Darshana's paper. Anybody would like to take over the floor for any questions? Yes. If not, I'll move on.
I would like to say something before Dr. Shamila concludes.
Okay, I'm sorry.
Actually, what I did in this paper, this might be a very basic level research, but this is what I experienced while I was reading for my PhD. That's non-availability of cases. We have statutory provisions, but we don't have case law, because that I noticed, I mean, this might be anecdotal because I didn't do any empirical research. I get to know from some informants, and that most of these kind of cases are settled down at the commercial high court level, or else they are not subject to appeals. So that might be a hindrance for academics to analyze these cases. Most of, not only undisclosed information cases, but also all IP law cases. So that perhaps if we can be able to bring the notice of the policymakers to at least to compile IP law decisions, company law decisions delivered by commercial high court, that might be very ideal way. I don't know whether this is viable or not, but this is one of the greatest need for academia. Thank you very much.
That in fact, that is one reason. I think the Faculty of Law some years ago, maybe probably 25 years ago, I can't remember, was a pioneer when it developed what's called the Colombo Appellate Law Reports, I think. And it went on for a couple of years, and I think it ceased to exist. Of course, at that time, that only reported the Court of Appeal and Supreme Court decisions. But now, I think, I don't know, my suggestion is for the Faculty of Law to consider whether it should report, because now more and more commercial cases are in the commercial high court. So when the unreported, I'm sure the faculty can get in touch with the relevant authorities and get the judgments and publish it annually or biannually or whatever it is, so that the judgments could be made available to the students and practitioners, and that will help to develop the law.
Thank you very much, sir. We can work on it.
Thank you, Darshana. Now our last presenter of the session 1, I will call upon Professor Indira Nanekara, Dean Faculty of Law, University of Colombo, will share her expert thoughts on electronic banking in Sri Lanka, legal protection against breach of data privacy. Professor's pre-recorded video will be played now. Yes, yeah, okay.
Very good morning. Thank you for this opportunity. My presentation is titled Electronic Banking in Sri Lanka, Legal Protection Against Breach of Data Privacy. Let me share my slides. So as I said, the title of my presentation is Electronic Banking in Sri Lanka, Legal Protection Against Breach of Data Privacy. This is the outline of my presentation. The development of ICT created new dimensions in the banking sector. The financial technology, electronic payments, and fund transfer system have paved the way to electronic banking. Products offered by banks have moved beyond conventional banking. It has provided an opportunity to banks to offer differentiated products and services to their customers using technology platforms. Also, the e-banking system was welcomed by customers as the wave of the future due to numerous conveniences such as savings on cost and time and the ability to transfer funds on 24/365 basis, irrespective whether the bank is open or not, because now the customer have access to banking services around the clock. What is electronic banking? In brief, where banking operations are carried out through electronic means without visiting a brick and mortar institution. Today, in Sri Lanka, banking sector is rapidly utilizing IT services for their operations. Most banks have deployed IT to transform their processes and to expand array of functions and innovative services to their customers. Banks also cut down operational costs, attract customers, and enhance productivity. The economic benefits of effecting payments electronically are now well established. This slide shows the numerous merits of e-banking. Our central bank is promoting electronic payments to establish a less cash society. If you look at this slide, you can see some of the areas of e-banking options offered by banks in Sri Lanka. Although the current IT environment has brought in favorable results for both banks and customers, the new technology poses new risks, which are complex and difficult to understand. So these are the new risks and challenges. We need to realize that while providing such tremendous opportunities and benefits, electronic banking carries risks which should be recognized, addressed, and managed prudently. The security concern is one of the important factors discouraging many internet users from electronic banking. There is a rapid increase of risks frauds, crimes, misappropriations, mishaps, challenges and threats that occur in the banking business. So the banks as well as customers are vulnerable to the risks of e-banking, even though regulations are becoming more and more stringent. As I mentioned, one important challenge banks which provide e-banking services face is the security challenge. Banks collect and keep very important confidential information of their customers, which they are bound to hold as confidential. As internet banking and e-commerce advances, the criminals can hack into an internet bank and steal important customer information. Therefore, it is the duty and the responsibility of the banks to constantly update security measures and stay updated on latest viruses and hacking tools and techniques in order to protect their customers' privacy. Maintaining a customer's information privacy is a key responsibility of a bank, because when personal information is misused, the consequences can be grave. For example, individuals can be influenced or manipulated by targeted information on digital platforms. Misuse or unauthorized disclosure of a confidential customer data exposes a bank to both legal and reputational risks. Because in spite of there being exceptions in law on this most significant and well-recognized rule on the maintenance of banking secrecy, it still remains as a stringent duty towards the customer. So we can see that the new advancement in technology have placed the banks to place all details of customers in complex computer systems, exposing such information to hackers and cyber criminals. Consumers in the majority of countries make payment by using credit cards under online transactions. There is a constant probability of being subjected to internet hackers and crackers. There are instances to show that whole IT system of the bank could be hacked, cracked, or cached by a third party within seconds. With hacking and cracking, no point how much you upgrade the IT security system. The moment a security method is introduced for protections, a counter method to get away with it will be developed. Therefore, it is practically impossible to provide a 100% secured e-banking service in the current context. As a result, it is essential having a sound regulatory framework in order to ensure secured and confidential e-banking service to the society. To minimize e-banking frauds and to mitigate malpractices in electronic banking, Sri Lanka has enacted number of statutes. So there are, if you look at this slide, you can see there are some of the laws in Sri Lanka to control the said crimes. Among these, Computer Crimes Act and Payment Devices Frauds Act are very important relating to cyber security challenges. Our parliament enacted these acts mainly to cover the matters related to confidentiality and integrity. Computer-related crimes and hacking offences are clearly identified and backed with the heavy punishments. I have mentioned some of the some of the important provisions of the Computer Crimes Act. You can see them, but due to the time constraints, I won't discuss these provisions in detail. But the issue is the legislature and other banks have not ensured that the required legal regime is not put in place, which provides the necessary environment for ensuring data or information privacy and security of the bank customers when they engage in electronic or online banking activities. Our legal regime governing electronic banking is not comprehensive and fully accomplished to extend a secure and safe environment for the customers to engage in electronic banking activities with full confidence that the privacy and security of their data or information would be securely protected. With the rapid digitization that is being experienced in the country, we need adequate legal and regulatory framework such as cyber laws and data protection laws in order to face new threats and challenges. It is a key and critical factor for a successful, user-friendly e-banking system in Sri Lanka. I conclude my presentation from here. Thank you very much for your kind attention. I'm happy to answer for your questions. Thank you.
Thank you, Professor, for the thought-provoking presentation. Now I leave to our panelists for further comments. Over to you, panelists. Yes, I hope Sir Giant also joined now. Okay.
Yeah. Yeah, I was disconnected for a short time. Shall we ask Mr. Swamada to go first, or Mr. Tunil?
Thank you. I think Professor Professor Indra's presentation is very good and very timely. She has referred to the various statutes that are applicable in Sri Lanka. Slide showed the entire list, almost the entire list, and also indicated that the difficulties of electronic banking, particularly electronic banking, almost everybody is resorting to today because of the present day context. When you can't, when it is very much more convenient to do it electronically than to go to the bank personally. But as the professor has pointed out, every time you think of security, there is also the hackers or people who want to commit the crime are smarter, and they have some way of getting over it. So I think what is probably required is to make some recommendations to the existing laws as to how it should be strengthened. I think there is no doubt that it should be strengthened, but the main thing is to find out, is to recommend, if possible, as to how it should be strengthened and what are the requisite amendments that should be made. So maybe that when the paper is developed fully, one may be able to have some thoughts on this so that it will assist the policymakers and the legislature to adopt those recommendations in any amending or new legislation that is forthcoming. Those are my initial comments.
Thank you very much, Professor Indra Naikar, your excellent presentation. In fact, this is a development in the banking sector at the moment in the country. And as you said, the cybersecurity is more important it will play a vital role to get the confidence on this electronic banking, especially the confidentiality, integrity, and the retrievability or availability. But as far as Act number 25 of 2017 is concerned, according to the amendment, section 23, these subject matters have been excluded. The transactions on a regulated exchange, foreign exchange transactions, that interbank payment systems, interbank payment agreements or clearance and settlement systems relating to securities or other financial assets or instruments, and the transfer of security rights in sale, a loan or holding of the agreement to repurchase securities or other financial assets or instruments held with an intermediary. So these subject matters have been excluded. We have to apply the Payment Settlement Act for this purpose. So under these circumstances, of course, that some other countries, when they exclude these subject matters, of course, they introduce different mechanisms for that. But what we can do is, the legislature has to think about this matter very seriously, to think about, especially under Electronic Transactions Act, when you come to section 567, of course, some provisions are there relevant to cybersecurity. Then, of course, for the banking transactions, of course, we have to introduce some mechanism. What the central bank has accepted, and the minister has issued regulation. They have given this task to ICTA. Mr. Janatha Fernando is there because for this cryptography service provider for security purpose, they have dominated ICTA for that purpose. So then, other than that, of course, we can't see any regulations also made under this act. So these are some loopholes we can see. As you said, Professor Nanakar, what we can see is there are some lapses, yes, but anyway that we have to think about this aspect, and we have to consider, and we have to compare this aspect with other countries. They also have this problem. There are threats. But as far as electronic banking and other normal banking concerned, what this expert, what they say is that the electronic banking is get more security than the normal banking. But other countries, they have taken a couple of steps ahead for the future, the work. I hope that Professor Ms. Indra Nanakar will consider this aspect, because they have gone to smart contract level. Now they use blockchain. They have not centralized banking mechanism. They have gone to that decentralized banking system. And even they have introduced Bitcoin system. This, of course, it will take at least a couple of, I don't know, with a couple of years or a couple of decades will come take this country. So we have to think about these matters. So when you come to this decentralized banking system, of course, the security will play that vital role. But before that, as you said, that we have to seriously think about, we have to have the proper policy on the security for the banking sector. Then this is my contribution, that my thought I can make as my contribution I can give. Mr. Janatha Fernando will address on that in detail. We have to go a long way, there is no doubt. But anyway, the step by step we have to go. And this COVID pandemic, of course, most of the customers, bank customers now, they are familiar to electronic banking. Now we can take this COVID also as an advantage to develop this e-banking system. Then we have to develop the insurance scheme. Insurance also the more important for electronic banking. When there's a cyber attack, ultimately it can't go to the customer. The bank must give that facility. Of course, that we have to change that culture as well. This is my thought for your presentation. Thank you very much, Professor Nanakar.
Professor Indira, actually, I thank you for taking on an important paper of this nature, which is which is also a very important contemporary topic in relation to our day-to-day business activity post-COVID, in the new normal that we are having to face. Digital banking and legal protection against breach of data privacy is a very moot and a contemporary topic, and I commend you for taking on this comprehensive research at this moment in time. And thank you once again for this excellent presentation. Just a couple of points based on what some of the other commentators made. The Electronic Transactions Act has been sets certain facilitation, legal recognition framework in the context of certain substantive measures that are articulated in Section 2 of the Act, and the exclusions contained in the Electronic Transactions Act to ensure the electronic commerce, electronic business, and e-government activities that are done in Sri Lanka can be maintained in a cross-border context when we entered the UN Electronic Communications Convention. And as we know, one of the default rules under the UN Electronic Communications Convention, the only international treaty on the subject of digital transactions at a global level, there are minimum exclusions that we have to include, which has been done and clarified through Act number 25 of 2017. Now, that is a necessary requirement when we have a binding treaty to ensure that our domestic electronic contracts are given legal validity and enforceability with reciprocal some degree of reciprocity vis-a-vis state parties to the UN Electronic Communications Convention. So that is an important matter we need to recognize. That's point number one. Point number two, in the context of digital banking, there are in every country that we know, they have got sui generis regulated statutes. So for RTGS, crypto security stating, you have a suite of legislation. Then for digital payments and facilitation thereof, you have the Payment and Settlement Systems Act and regulations made thereunder. Now, coming to this point about protection against breach and measures connected with that, while the Payment and Settlement Systems Act provides the foundational framework to ensure security to the transactions, the Electronic Transactions Act has enabled the use of electronic signature frameworks with application in the context of ensuring security. So that work has already been done. Having said that, one area of attention perhaps we might like to add here is that in addition to the Computer Crimes Act and the Payment Devices Frauds Act, what is important is that Sri Lanka has become a state party to the currently available international standard on criminal justice enforcement of cybercrime, namely the Budapest Cybercrime Convention, and the banking sector FIU fraternity, together with the criminal justice officials, to collaborate at a global level under an enhanced electronic evidence gathering platform provided under the Budapest Cybercrime Convention. So it is a global treaty where 66 countries are part of, and other countries are coming on board. US, Canada, Japan, Australia, and countries like Philippines, South Korea, and others are now entering the convention. So in that context, to see whether greater protection to the banking sector can be ensured through the framework of the Budapest Convention by bringing in additional safeguards under domestic law to protect our ecosystem. So that's the only point I wanted to add. And having said that, in the context of data breaches, protection of the customers in online banking, the new data protection legislative framework will have some measures that will give enhanced protection to customers in a digital banking ecosystem. In fact, this data protection bill came about as a request from the Central Bank of Sri Lanka and SEC to protect their domain specific requirements and to ensure greater protection to that particular area of activity. And I would like you to consider to look at certain safeguards provided under that draft. For example, Section 12, the Data Protection Management Program ensures the banks and financial institutions will have to have an internal governance arrangement to better protect customer data beyond which they are governed under the present Banking Act or the Monetary Law Act, right? So some additional benefits have come in through the proposed legal framework. You might like to critique that and consider that when we want to enhance that paper. And finally, Section 23 of the bill. In other words, customers in the digital banking ecosystem will have the benefit of knowing well what has in their data has their data been subject to a breach in a timely manner, unlike at present. So with that law coming in, some of the concerns that you have addressed in your paper might be addressed. So you might like to add that if you may want to consider going in depth. Thank you very much, Professor Indira, for that fantastic paper, a very timely contemporary subject at this present moment. Thank you.
Thank you very much, sir. Thank you very much for your recommendations. I will certainly incorporate them in order to improve my paper. Thank you so much.
Thank you, panelists. I hope we don't have any more questions from the participants. Before we conclude, yes.
Question, I think.
Yes, Professor.
Yeah. You can now when it comes to crime or money laundering or whatever, now this privacy law will not work. That's not a defense, no. What I feel is now because of this electronic banking, the banks are sleeping. Now, my opinion. Now, recent news, if you hear, a beggar is found to have an account with about few millions in credit. The beggar has never gone to the bank. A drug dealer has used him to deposit through using the machine. There is corruption going on at a very high level now. Yesterday, a commissioner of a department coming and saying illegal importation of vehicles and all. For everything, the bank is being used. Now, the banks are like sleeping because of electronic banking, and they may say that we are protecting the privacy. Now, what is your argument for that? Comment on that,
I'm in my recommendation, that is one thing, how the bank should act. I mean, a bank has to be proactive. So I'm not totally agree with you that banks are sleeping. But I actually suggest that banks must introduce good security features and also measures to protect transactional security to ensure the privacy of customers. So that is my suggestion. I'm coming up with the suggestion. The role of the bank in this regard.
Yeah, so in fact, I want to come to Professor Indira's defense here. I think the banks, unlike many other entities, the banking sector has been excellent. They have done a unique endeavor. They have done the best possible. They have taken the best possible efforts in recent times, so the last 7-8 years, to modernize their sector and adopted safeguards in line with international standards. So one point I missed, which I want to emphasize, in the digital banking ecosystem, we are the first country in South Asia, Professor Shanti, which introduced a banking sector CSERT, a compute emergency response, a specialized team operating out of Lanka Clear on a public-private partnership model, and they are monitoring traffic whilst protecting privacy of customers, they are monitoring the general traffic on a minute by minute basis, 24/7, 365 days. I mean, you don't find that anywhere in South Asia. So the banking sector has invested significantly in that domain, and within the framework of the governing rules set up under the steering committee of the central bank, that activity of regulating and enhancing to ensure enhanced protection to customers has made sure that in the COVID era, our digital banking activity is a temporary requirement. Thank you.
I think Mr. Jayanta,
Sri Lanka was grey listed for money laundering. Sri Lanka is considered as a hub for money laundering. Now they have fought it to get it lifted.
Yeah.
So that is also a point.
All that is correct, Shanti, but the issue is when you consider the situation in developed country also, what we can understand practically, it's impossible to provide a 100% secured e-banking solution because of current context, because of hackers, crackers, and cyber criminals. So it's not limited to Sri Lanka. It's like a global issue.
Okay, thank you, Indira. Thank you.
Professor Indira.
Yes, sir. Yeah.
Professor Indira, what I can say is because without any delay, legislature must introduce this data protection law. And in the meantime, since we have signed Budapest Convention, this is high time to introduce computer fraud under Computer Crime Act and introduce some cyber security, especially under electronic banking law or whatever. So this maybe we have to expedite it.
Yes,
I agree with Sunil.
Thank you. Your recommendations.
Okay. Thank you, Professor Segarajasingam. Thank you, Professor Indira Nanikara. Thank you, panelists. Before we conclude the first session, now I would like to extend my invitation to Professor Nazima Kamardin, Acting Head Department of Commercial Law, to present her brief vote of thanks.
Good afternoon, everyone. I would like to keep this brief because we have to get the next session. But I would really like to thank and congratulate all the presenters for engaging in their research, engaging in cutting-edge research, making it relevant to the new situations that we're facing. And also really offer my heartfelt thanks to our panelists, Dr. James Swaminathan, Mr. Sunil Aberatna, and Mr. Jayanta Fernando, because without your expert comments and your observations and your insights, this research would never reach the standard that is required to be accepted into publishable journals, which is something that we see as very important. That paves the way then for it to find its way into law reform. So I would like to conclude this particular session by thanking all of you for reading the abstracts, reading the papers, being prepared, and offering extremely practical viewpoints to all our presenters to take their research forward. Thank you very much. Over to you, Shamila. What shall we do? Are we going to the next session?
Yes, Nazima, thank you. Thank you so much. Yes, we are now going to move second session 2. Is it clear?
Yes, it's clear.
Okay. Let me check first how our panelists have joined.
Yes, I think they are both there, and Dr. Swaminathan will stay with us till 1:30. Isn't that right?
Yes.
Yeah.
Okay. Thank you, our panelists. And now I move on to the session 2. We welcome our eminent panelists, Honorable Justice Arjuna Obesekara. Justice Arjuna Obesekara, who holds a master's degree in commercial law with honors from the University of Cambridge, joined the Attorney General Department as a state counsel in January 1993. He was promoted as a senior deputy solicitor general in 2015. He has wide experience in the field of commercial law, including banking and arbitration, and in the field of public law. He has appeared as a counsel for the state in litigation across all courts, as well as in several international commercial arbitrations, including investment arbitrations. He has functioned as a consultant to the Securities and Exchange Commission and the Public Enterprises Reform Commission, and was a member of the Company Law Advisory Commission. Justice Obesekara was appointed as a judge of the Court of Appeal in April 2018. and has been a member of the bench hearing predominantly writ applications. He was appointed as the President of Court of Appeal in December 2020. We are honored to have you, sir, today. We also have Dr. Dinusha Pandiratna. Dinusha Pandiratna is a specialist in international law and foreign policy. She is an advisor to Veritas Research and previously served as Executive Director of the Lakshman Kadirgam Institute of International Relations and Strategic Studies in 2015 to 2018, and subsequently as non-resident fellow of Lakshman Kadirgam Institute. Prior to her appointment at the Lakshman Kadirgam Institute, Dr. Pandiratna was an assistant professor at the Faculty of Law at the Chinese University of Hong Kong. She is an attorney admitted to practice in the state of New York and previously worked at Milbank LLP, a law firm in Wall Street. Dr. Pandiratna serves on the board of leading bank as well as non-profit organization in Sri Lanka. She is a member of Asian Pacific Leadership for Nuclear Non-Proliferation and Disarmament and previously of the International Advisory Board of the Asian University for Women in Bangladesh. Dr. Pandiratna received her initial degree in law with first-class honors from University of Oxford and her master's and doctorate from Yale Law School. Thank you very much, Doctor, for your presence today. I move on to the next presenter. Our next presenter is our freshly joined younger staff, Mr. Samagi Aberatna, lecturer from Department of Private and Comparative Law, will talk about adapting civil forfeiture laws for offences falling under money laundering in Sri Lanka, critical analysis. We'll find out to what extent Sri Lankan law complies with international instruments in strengthening the laws to combat money laundering, whether criminal forfeiture is sufficient to combat, or Sri Lanka also should adapt civil forfeiture like the United Kingdom. Now we listen to Ms. Samagi's video.
Good afternoon to you all. When someone follow drug, he get drug dealer and drug addict. But if he start to follow money, nobody knows where it is going to take him. That's how money laundering is. Money laundering is a technique as old as money itself, and its association with crime and criminality is long-standing. Law enforcement agencies in Sri Lanka are fighting an uphill battle to combat and prevent money laundering. In this context, my research is limited to the topic adopting civil forfeiture laws for offences falling under money laundering in Sri Lanka. This is a comparative study which referred the provisions related to forfeiture of assets under Prevention of Money Laundering Act 2006 in Sri Lanka and civil forfeiture under Proceeds of Crime Act 2002 in United Kingdom. This is the outline of my presentation. Ladies and gentlemen, let's get started. Money laundering is a process by which unlawfully acquired proceeds are made to appear to have been derived from a legitimate source. As the result of Article 31 and 54 of United Nations Convention Against Corruption, most of the jurisdictions, including Sri Lanka, have adopted forfeiture of property for offences falling under money laundering after convicting the accused. This research has found that this criminal forfeiture is not sufficient to combat and prevent money laundering in Sri Lanka. The objective of this study is to analyze whether Sri Lankan law complies with international instruments in strengthening the laws to combat money laundering, focusing on forfeiture only on conviction. Further, how Sri Lanka can comply with international obligations to prevent the serious consequences of offences of money laundering. This is a doctrinal study based on secondary resources. Throughout this presentation, I will discuss criminal forfeiture provisions in Prevention of Money Laundering Act in Sri Lanka, consequences of criminal forfeiture, and international obligation to adopt civil forfeiture laws, and what we can learn from United Kingdom civil forfeiture regime. First, we will look into the criminal forfeiture under Prevention of Money Laundering Act 2006 in Sri Lanka. Section 13, subsection 1 of the Prevention of Money Laundering Act 2006 provides when a person is convicted of an offence of money laundering, the properties derived from that unlawful activity shall be forfeited to the state. The aim of the forfeiture is to take away the profits of crime and make sure that crime does not pay. And further, as per the section 7, subsection 1, only freezing orders are available before conviction. And also it can be issued by a SI officer in police. It shall be in force for 7 days only, and High Court can extend it only for 1 year. The consequences of this criminal forfeiture may be, until conviction, the property may still under the name or ownership of the offender. And also, when property is subjected to the police custody, there are chances for misuse. Most importantly, sometimes it is impossible to commence criminal proceedings where the launderer has kept himself or herself distant from the crime and control outside the regime, and also where the launderer dies, leaving recoverable assets or transfer them to a third party. On contrary to that, civil asset forfeiture allows the confiscation of proceeds of crime in absence of criminal conviction. This procedure can be conducted against the assets themselves that has been derived from an unlawful activity without being linked to any action against a person. Forfeiture is commonly used in United Kingdom, United States of America, Australia, etc. Civil forfeiture laws do not require proof of illicit origin beyond reasonable doubt. Instead, it considers proof on a balance of probabilities. Now, we will look for the international obligation of Sri Lanka to adopt civil forfeiture. Under Article 54(1)(c) of United Nations Convention Against Corruption and Financial Action Task Force Recommendation number 4 and 38, we are under obligation to take necessary measures to allow confiscation without a criminal conviction. This obligation has been occurred when Sri Lanka has ratified UNCAC on 31st of March 2004. Further, as a member of Asia Pacific Group on Money Laundering, which has the mandate to ensure the standards set out in FATF recommendation, Sri Lanka obliged to follow those recommendations. Then, let's see what we can learn from United Kingdom's civil forfeiture regime. Section 240 of Proceeds of Crime Act 2002 make provisions for civil recovery, which is also referred as non-conviction based asset forfeiture. This alternative approach made use of civil proceedings to target criminal assets. Part 5 of the corresponding act is purportedly a civil procedure which requires a proof of balance of probabilities. This has been stated in Section 241, subsection 3 of Proceeds of Crime Act 2002. The confiscation regime of United Kingdom is designed to give effect to the principle that criminals should not pay. Let's come back to Sri Lanka. Significantly, in 2019, Commission to investigate allegations of bribery and corruption proposed a legislative amendment by proposing Proceeds of Crime Act, which include non-conviction based confiscation. However, all of these policy suggestions are still pending. Therefore, finally, this research recommends to adopt Proceeds of Crime legislation, including civil asset forfeiture for offences falling under money laundering, and also to take necessary steps to train new skills for investigators, lawyers, and judges to familiarize with this non-conviction based forfeiture proceedings, and also to take further steps to comply with international obligations. Therefore, this research has been concluded that it is high time for Sri Lanka to adopt civil forfeiture laws concerning money laundering to comply with international obligations by learning a lesson from United Kingdom's civil forfeiture regime. Ladies and gentlemen, it is time to act, not to wait or just to propose. Thank you so much for your attention. If you have any questions, you may ask now.
Thank you, Ms. Samagi, for your excellent analysis. We will listen to our panelists for their comments and suggestions. Panelists, over to you.
Would Honorable Arjuna Obesekar like to go first, and then I?
You can give your comments first. I was waiting for you to come on, so I'll allow you to go first, and then I'll follow.
Sure. Let me turn on my video. Right. Well, first of all, thank you to Dina Nakara and also to Professor Kamadin for inviting me to be a panelist on this session. And thank you also to my fellow panelists as well. Ms. Aberatna, I want to congratulate you on delivering a very clear and convincing presentation. I am not an expert on anti-money laundering laws, but I will try to cover sort of more of the policy aspects of your presentation, because you rightly raised the policy context. And I think in order for your very clear legal arguments to move forward, it might be helpful to...
Can you please mute Aberatna? Yeah.
Thank you. So in order for your very clear legal presentation and legal argument to move forward, it might be helpful to consider the policy priorities of for your legal arguments. So I think there was some discussion in the last session about the Financial Action Task Force grey list. That indeed, that is a priority for Sri Lanka to remain off the grey list. They were actually delisted of the grey list late last year, but there's always the risk of being put back on that, especially because post-COVID, there has been some relaxation on sort of foreign exchange, incoming foreign exchange rules. So whereas previously, I think the rules were a bit stricter about that because of Sri Lanka's acute need for foreign exchange because of its debt situation, there has been somewhat of a loosening of the rules for receiving foreign exchange. So in the context of those sort of post-COVID changes, it is important for us to maintain the anti-money laundering focus and remain off the grey list. In addition, you could speak about other incentives for your legal argument, other policy incentives for law reform on I think the Basel Index, which ranks countries according to their risk for money laundering. Sri Lanka is actually second in South Asia after Afghanistan. It was had a fairly good ranking around 2014, 2015. It was around 51st in terms of risk. So it's good to be lower on this list, not to the top of this list, because the top countries have the highest risk. So it was 51st, and now I think in the most recent Basel Index on money laundering, it has moved to 23rd. So it's now moved considerably higher up the risk level. And all those perceptions are not good for Sri Lanka's international confidence in its domestic financial institutions. They could also affect financial institutions' credit ratings by institutions like Moody's and Fitch. Could possibly also affect the sovereign credit ratings, which we know have been adversely affected this year several times. So, for all these reasons, to preserve Sri Lanka's good or slightly improving reputation recently in terms of getting off the grey list last year to maintain that reputation. These are all policy reasons, for Sri Lanka to consider the very strong legal arguments that you have made. If the other panelists may have some comments.
Yeah.
Shamila, Arjuna sir has to unmute.
Yeah, I have done that now. Okay.
Yes, sir. We hear you.
Yes, sir. We can hear you.
Let me, I think, endorse what Dinusha just told you. Ms. Abhiratna, it's an excellent presentation on money laundering. And Dinusha has also told us about the importance of ensuring that we know that we maintain, or we were out of the grey, we were put into the grey list at some point of time, we were taken out. It's important that we continue that status. One of the matters that you discussed, Ms. Abhiratna, was with regard to this going in for civil forfeiture. I think it's high time that we did that, because when it comes to a criminal conviction, we all know the burden of proof is beyond reasonable doubt, and that's the burden of proof that the criminal courts insist upon, because we are talking about putting people behind bars for a fairly long period of time. So in order to ensure a correct balance, the evidence that is looked for is very strong, and so there may be situations where the evidence that a person is not convicted because the court was not satisfied that the burden of proof has been discharged, but nonetheless there is evidence that on a lower scale for balance of probability, which is what you're advocating in a civil forfeiture, that the evidence would have been sufficient. So I think it's relevant, and I think it's time that we looked at civil forfeiture. And also, I think when I looked at your the paper that was the brief introduction of the subject that was emailed to us earlier, the police again is a striking of a balance to ensure that the police does not have a lot of powers. That's why they are given limited powers of what we call freezing, or to obtain a freezing order for a period of 7 days on their own, and thereafter to move the High Court, so that the High Court is presented with all the material, and it's the High Court that decides to extend the freezing order. So that's and would I endorse going for any further freezing orders without the involvement of court? Certainly not, because as I said, we need the proper balance needs to be struck. So about the protection of these items, some time ago we had the opportunity of looking at some of these developments in the United States, and they have a situation where if it's a perishable asset that we're talking of, where the proceed of crime is a perishable asset, there's provision in their law to sell that particular asset and to deposit the proceeds of that sale in a special account, so that the asset itself and the value of the asset is maintained, so that in the event of a conviction, then the forfeiture is of you've been able to forfeit the actual value as opposed to the value which might the asset which might have dilapidated by that time. In that particular experience that we had in the United States, they also pointed out that, for example, it might be an aircraft that is now being frozen, or the possession is taken pending a High Court case, and that it takes a lot of money on the part of the government to maintain that plane. For example, they had to find parking space for that particular plane. So there are lots of expenses where, in those circumstances, you could go to court and ask for a special order to sell that particular asset and to deposit the funds. So airplane is not perishable, but it can yet be done. So those are some of the thoughts, but I certainly welcome the idea that it's time that we move towards civil forfeiture.
Ms. Abhiratna?
Thank you so much, Justice Obesekara and Dinusha. Madam, I'm still researching on this area and I will be soon finalizing my paper. And these ideas and comments are very valuable as a fresh academic. So I will be incorporated all of these ideas into my final paper. And thank you so much for your valuable comments.
Professor Segarrajasingham, do you have any questions? Okay, that's it was okay.
Samangi, it's a very good presentation. If you are developing a paper, now rather than suggesting a new law totally, that is Proceeds of Crimes Act like UK, that may be okay. But don't you like to suggest any amendments to the existing Anti-Money Laundering Act?
Madam, I was researching whether we can put all of these seizure, forfeiture, and everything into one statute, like Proceeds of Crime Act. So it will be more convenient and it will help for the law enforcement agencies to act efficiently. So that's why I am proposing, but I will consider your suggestion as well and will work on that, madam, also.
Okay, thank you.
Thank you. I believe Ms. Abhiratna will take all the important points from our eminent panelists, comments to develop her full paper. Thank you, panelists. Thank you, Professor Segarrajasingham. Now I call upon our next presenter, Dr. Pathirana, Senior Lecturer, Department of Commercial Law, will speak under the title on The Balance Between Principles and Income Tax Law, a commentary on principle of taxation. We'll see whether Sri Lankan tax law covers the elements of principle of taxation to achieve proper tax governance in Sri Lanka. Dr. Pathirana's pre-recorded video will be played now.
Good afternoon to you all. My presentation is based on the balance between principles and income tax laws, a commentary on principles of taxation. The tax revenue is a primary constituent of the government's fiscal policy. The government of Sri Lanka imposes taxes mainly of two types in the forms of direct taxes and indirect taxes. An income tax is thus a part of society's distributive mechanism and must be designed in accordance with the governing principles of social justice. A properly designed income tax would help to achieve the goal of economic development by generating more revenue to the government. It helps in balancing income inequality, and also taxes can be reassure or discourage certain activities or business of the public with compared to other governmental policies. Taxation also helps with regulatory objectives and developmental objectives in economic development. The tax laws would not have to change from year to year, and there would be less uncertainty for people in making investment decisions. More stability in the tax system would create a more certainty in business climate. Therefore, all these measures stress to introduce consistent, efficient, and simple tax system to the country. In this context, Jeremy Bentham, who founded utilitarianism, said that two sovereign masters, pain and pleasure, govern the mind. Utilitarianism is currently the dominant theory of political morality, asserting that all men seek to maximize their pleasure and minimize their pain. Therefore, any private or governmental action, any law, and any political structure are to be judged according to the tendency which it appears to have to augment or diminish the individual. In the theory of justice, John Rawls argues for a principled reconciliation of liberty and equality as the basic structure of a well-ordered society. Social justice is the concept of fair and just relations between the individual and society. The social justice principle holds that societies should ensure fair distribution and equal opportunity, which begins the idea of justice as fairness. Further, tax policy is founded on the four maxims identified by Adam Smith in his Wealth of Nations. Those are efficiency, fairness, simplicity, and revenue sufficiency. These subjects are widely accepted by modern policymakers for draft and effective tax laws for both taxpayers as well as governments. The above discussion shows that taxation is a principal issue in well-ordered societies with regard to financial administration and strategies. Moreover, the system of income tax should not be a burden on the people of the country. Thus, it is very important to follow the basic theories and principles which have been identified under tax law philosophies. There are many issues in prevailing Sri Lankan income tax regime. The fact that the tax system is not delivering potential revenue is the main issue. According to Sri Lankan data sources, almost 9% of revenue comes from taxes and non-tax resources account for 10%. However, 80% of tax revenue comes from indirect taxes and only 20% come from direct taxation. The major reason for the above percentage is the narrowness of the tax base. Furthermore, it did not broaden according to the economic activities and other development projects in the country. All these factors have come about because of the complicated and unorganized income tax law base. The gaps and loopholes in the Indian Revenue Act are leading to such problems due to avoiding basic principles of taxation. Prevailing such lacunas, the recent governments have taken many initiatives on tax administration process and tax laws. The main expectations of such amendments were to apply tax principles and theories for the betterment of the country as well as taxpayers. The Yahapal government and the newly recruited government both have introduced different scenarios to the tax process of the country. The Yahapal government, with the expectations of considerable income, introduced the new Inland Revenue Act on income taxes. Similarly, the corporate tax revisions, revision of withholding tax, pay tax revisions, and capital gain tax were introduced. However, the newly elected President Gotabaya Rajapaksa approved mandate to abolish taxes such as pay, nation building tax, withholding tax, capital gain tax, bank debit tax, and to reduce VAT tax rate from 15% to 8%. All the public and private sector workers have been completely released from the pay-as-you-earn income tax scheme, pay scheme, and all the persons who earn an income from more than 250,000 rupees will be subjected to the income tax. The budget revenue proposals show the government has set a target in its medium-term economic plan to increase from 20% to at least 40% the income tax contribution to total tax revenue. Budget 2021 was presented with the focus on economic developments and creating a healthy society amidst the COVID-19 pandemic. According to the proposals, it includes the government intended to introduce a simplified three-tier corporate tax structure. The Prime Minister proposed to maintain the VAT unchanged at 8%. Outstanding dues on the taxes, such as proposed to be settled through online tax administration mechanism. Fourth, it will be mandatory for all companies to file their taxes only on an e-filing system with effect from 1st April 2021, and the use of the tax identification number in all tax and tax-related transactions. Next, it is also proposed to establish a special tax appeals court to resolve tax appeals. He proposed to introduce the required changes to the Department of Inland Revenue to facilitate enhanced self-compliance and strengthen tax audits. Similarly, he pointed out that the various units in place for this purpose will be brought under one large taxpayer unit, targeting those large taxpayers to operate under the direct responsibility of the Commissioner General of Inland Revenue. In its budget proposals, the government looks at introducing several measures, including broadening the tax base, simplifying the tax rates, reducing the number of taxes, facilitating voluntarily compliance, avoiding politically motivated tax amnesties, and tax concessions to enhance tax revenue. Broadening the tax base and raising tax revenue are policy priorities for the government. Any income tax reform results in widespread distribution of income in an economy. It has been identified that the changes in Sri Lankan tax policy and laws have generally aimed at increasing tax revenues without properly considering the impact on welfare in terms of income distribution and equity. More significantly, it has to be emphasized that it is the administration which determines the effectiveness of the revenue system. In analyzing the current issues and problems of taxation in Sri Lanka, it is necessary to examine the adequacy and efficacy of the tax laws. Further, it is important to see how effectively the policy and administrative measures have solved problems that have arisen due to inadequate tax laws and regulations. It is said that taxation is the price paid for civilization. Paying taxes is an obligation placed upon the people and is necessary to finance the various expenditure of a legitimate government. Finally, tax administrators are given wide powers to determine the tax base, to verify information provided by the taxpayers and third parties, and to impose and collect the tax due. Thank you very much.
Thank you. Thank you, Dr. Pathirana. First of all, may I confirm Dr. Pathirana is with us now?
Yes, Dr. Shamila, I'm here. I can hear you.
Okay, thank you. Thank you, Dr. Darshika, for your excellent video presentation. Now I open the floor for our panelists for their comments. Over to you, panelists.
Again, maybe I'll go first if that's okay. Justice Obesirka, is that? I'll just have some brief comments. Thank you very much, Dr. Pathirana, for a really interesting and instructive presentation. Again, I'm not an expert on tax law, so I'm going to keep my comments to the broad aspects of your presentation. I think what was especially strong in your presentation was your attention to the policy context, an aspect I discussed also with respect to the first presentation. You really set out very clearly the policy priorities of the government in terms of broadening the tax base, as well as the priorities of the most recent budget. So I thought that policy context of the presentation was extremely strong. Just some suggestions about, I guess, the methodology of the methodological aspects of the presentation and your paper. You started off with identifying Adam Smith's 4 principles of taxation, and I think that's a really interesting and clear basis for the methodology that you will be adopting in the paper, because you're starting off by stating sort of accepted principles. A couple of comments on that, however. One is that, Adam Smith's principles are generally associated with very free market economies. So I guess I had a question as to whether you needed to just briefly justify why you were choosing those 4 principles in respect to Sri Lanka, which is not considered as much a free market economy as some other economies. So you might just want to just briefly justify your selection of the 4 principles, and by which you'll be judging Sri Lanka's taxation system. And then I think it might be helpful also then to sort of explain those principles in a bit more detail. I think you're probably planning to do that anyway in the paper, but this is just to flag that need to just detail them more. For example, you could ask, how will those principles intersect with each other? What is the prioritization of those principles? What's the accepted prioritization? Does efficiency go before fairness, or so forth? So a bit more explanation about the interplay would I think be helpful. And then when looking in terms of methodology, when examining different aspects of Sri Lanka's taxation system, to sort of just keep going back to those standards, because you've identified the 4 principles, but then when you're sort of continuing with your analysis, to sort of structure it accordingly. So, to keep judging the laws by those principles. Otherwise, sort of perhaps the principles, the reader or the listener may not be able to make the connection with their own lay knowledge between Sri Lankan laws and the principles. So that was just a sort of methodological issue. And on you mentioned sort of the third point I want to mention was about the inadequacy of laws that you clearly pointed out. You might also want to just consider implementation issues. So there seems to be a sort of public perception that there are adequate laws, perhaps, but very inadequate implementation. So just to take a very practical example, you talked about the need to broaden the tax base. There's a massive tuition industry in Sri Lanka, and tuition teachers are paid in cash and therefore are not part of this tax base that we need to broaden. How does the government go about doing that as a practical way There are some interesting developments post-COVID in particular about the move. We talked in the previous session about digital banking. So many more payments, including to tuition teachers, are being done online these days. Is there a possibility for a government to track those more and to bring those types of industries, previously cash-only industries that are now digital payment industries, to bring them within the tax base? In countries like the US, for example, when you're making an online payment, you are often required to say, this is for education, this is for your rent, this is what. So in that respect, people that are transferring all these payments online to, for example, tuition teachers, would have to say it's for education. And the government is then able to track, okay, these are now tutors who are getting paid. How do we start tracking them and bringing them within the tax base? So that's an implementation issue. So basically the three issues, I think the policy perspective is very clear. You may want to discuss and detail more the methodological aspects in terms of identifying the principles and how they interact with each other, and then tracking how Sri Lanka's tax laws fit those principles, and then thirdly, address the possibility for better implementation of the laws. Those are my comments.
Okay, madam. Thank you very much. I'll include those comments into my paper. Thank you very much.
Dr. Patirana, let me also add to what Dinusha just told you. It is a good paper. I have a few comments though. Dinusha did speak to you about the implementation, and I think some of the issues that we have, some of the concerns that people express relate to the implementation, that there are certain people who are left out, and how is it that they are not brought in. If I remember right, the 2017 law did provide for every person above a particular age to come forward and register themselves. I'm not sure of how it has been implemented. It would have, I think, one of the concerns I had with your presentation was you did say that there is an inadequacy of the tax laws. It would have also been useful if you were able to itemize what those inadequacies are, or in your view, what needs to be improved. Because we've had, since 1938, we've had the Inland Revenue Act, 1938 going on to 1979, 2000, 2006, and then 2017. The basic method of calculating the income tax of a person has, to the best of my knowledge, has remained the same. There is confusion, I must say, and that's where I agree with you with regard to the concessions that are granted, or what we call what are the payments that are not counted, or what's the income rather that is not counted in the calculation of tax. So that's one concern that I had. The other thing, I think your concern probably is more weighted towards the changes in the rates and the different items that get taxed at different times. Of course, we all need to keep in mind that the tax rate cannot be static, and that the government of the time will have to take into consideration the practical realities and the ground situation when they determine the rate. With regard to enforcement, I'd just like to tell you that the legal regime that is there in the Inland Revenue Act, again, which has been there right from the beginning, is that a taxpayer who gives a return, his return will be accepted if the assessor or the office of the Inland Revenue Department is happy with the assessment. If it's not, then he is informed of the reasons. So it's a legal requirement that is told why his assessment cannot be accepted. He's entitled to reasons in terms of the law. And then he has a right of appeal to the Commissioner General of Inland Revenue. If the Commissioner General of Inland Revenue also does not hold with him, then he has a right of appeal to the Tax Appeals Commission. And thereafter, from the Tax Appeals Commission also, he can come to the Court of Appeal by way of a case stated. So that process takes time. And in the Court of Appeal, we have cases that were filed, a few cases that were filed as far back as 2012, 2013. It is probably with that in mind that the proposal was made to with with the enhancement of judges of the Court of Appeal to to establish a separate tax code, which has now been done, where there's a dedicated tax court hearing only tax appeals, in addition to another court where about 80% of its work will be tax appeals, so that the determination of tax appeals can be concluded as expeditiously as possible. So those are some of the comments that I thought I will talk to you. Also, you did mention about loopholes, so it might also be useful for you to elaborate on two things: elaborate on the loopholes and elaborate on the inadequacy of the laws that you spoke of. So those are some of the comments I thought I'll share with you.
Could I please inform the panelists that Darshika lost connection, but she's with me on the phone on loudspeaker. Darshika, would you like to comment now?
Yes, madam. Thank you very much. So thank you very much. I heard everything through the phone with the help of Madam Nazima. I'll incorporate and I'll consider all those comments of yours and Madam Dinusha. Thank you very much for your comments and concerns. Thank you very much.
Stay on the line, Darshika. Shamila, are you asking for any more comments or questions?
There are no questions, Nazima. She can go now.
Okay, right. Thank you.
Okay. Thank you. Thank you, panelists, for your excellent analysis, your comments, your suggestion on Dr. Patrana's research. I hope that would definitely help her to improve her final paper for her publication. Now we will listen to Professor Nazima Kamardeen, Acting Head, Department of Commercial Law, about her expert finding on global economy in jeopardy, rethinking trade liberalization in the post-pandemic era. Professor's pre-recorded video will be played now.
Good afternoon. Thank you for giving me this opportunity to make this presentation. I would like to share my screen, which shows my presentation slides. I hope you can see the screen now. My presentation is titled Global Economy in Jeopardy, Rethinking Trade Liberalization in the Post-Pandemic Era. To begin with, the background and rationale is that the COVID-19 pandemic has affected every aspect of not only our economy, but economies in countries across the globe, and it has negatively impacted jobs and livelihoods. Against this backdrop, I have analyzed the fact that the interdependency of global trade has resulted in every nation across the globe being affected. Today, more than ever, we are living in the global village, and while this has had its benefits, it has also had its downside in the fact that incidents that have taken place in one country have rippled across and made themselves noticeable in other countries as well. I will first describe the rationale for trade liberalization, examine the performance obligations and opportunities for protectionism in the WTO, assess the impact of COVID-19 on global trade, evaluate the responses, rights, and responsibilities of nations, and then analyze the implications for Sri Lanka. The modern trading system is built on the premise that no country is self-sufficient. In the years following World War II, countries realized this. And though there are united efforts to come up with a global organization for trade did not materialize, what was left as the General Agreement on Tariff and Trade was a recognition of the fact that protectionist trade policies were extremely detrimental to not only the overall global trading arena, but to the economies of individual countries themselves. So when the GATT was formed, many countries subscribed to the view that progressive reduction of tariffs would help in trade liberalization. Today, no country is self-sufficient, and theories such as comparative advantage have helped countries to focus on the production of goods and services that they are extremely competitive at, leaving other goods and services to be produced by other trading partners. Indeed, it is important in the global trading arena that each country is able to produce goods and services at some sort of expertise so that these can then be used to bring in the foreign revenue that is required to support other sectors of the economy that require imports. When we analyze the WTO and the performance obligations and the opportunities for protectionism, we find that the most favored nation and the national treatment standards operate to ensure fairness. The most favored nation ensures that no country is treated better than another except under preferential or regional trade arrangements. The national treatment standards ensure that foreigners are given the same treatment as locals and are not discriminated unfairly against. Unilateral actions relating to tariffs are not permitted, so no country may unilaterally raise tariffs on products from other countries. Further, in the WTO, to initiate a dispute settlement, the nullification or impairment of trade benefits is the standard to be proved. Therefore, countries may not covertly breach trade agreements and plead that they have not overtly breached them and that therefore they are not in breach of trade obligations. However, with all these mechanisms in place for trade liberalization, like the progressive reduction of tariffs and the elimination of quantitative restrictions, members are indeed allowed to take protectionist measures in order to safeguard their human, animal, health and plant life, as well as for security reasons. Articles 20 and 21 of GATT permit this, and they only require that the measures taken do not constitute a disguised restriction on trade. If they are not a disguised restriction on trade and they are taken in good faith for these purposes, protectionist measures are allowed. The impact of COVID-19 on global trade cannot be understated. All the statistics are extremely gloomy, and we would see that world trade is expected to decline up to 32% by the end of this very month. Asia, where we live, is going to be hit because exports from this region are going to be severely affected. And service sectors, like for example, our own tourism industry, are already suffering because they are very dependent on a number of supply chains, most of which have been disabled. From a humanitarian point of view, the number of people at the poorer end of society who will suffer from hunger is expected to double. Against this backdrop, what are the rights, responsibilities, and the responses of nations? We can see that lesser developed nations have already begun to restrict imports in a bid to reserve foreign currency. Because for these countries, the foreign reserves are extremely low, and their balance of payment problems have already begun to surface. However, the world's major exporters have urged nations to continue to allow imports and to export goods without denying trading partners access to these. However, as we have noted before, the WTO cannot prevent protectionist measures that are taken by various nations if they fall within the ambit of Article 20 or 21. When we look at Sri Lanka, we find that as early as May of this year, the government began imposing import restrictions. There was a total ban on the import of cars and other luxury items. Some of these have been eased, but yet we continue to have certain import restrictions. This move has drawn criticism from major trading partners such as the EU, who have warned Sri Lanka that global trade is not a one-way street and that there must be a certain amount of give and take. If we look at the legal standpoint, Sri Lanka would be well within its rights under the WTO to engage in these protectionist activities for the welfare of its economy, because ultimately the state is responsible to ensure that its citizens are well looked after and that the domestic situation is at its optimal level before it engages in looking at whether its obligations to other trading partners are met. However, pressure for countries like Sri Lanka from influential trading partners cannot be ignored, especially like the EU, if they are also giving us concessionary trading terms such as GSP Plus and so on. Coming to the conclusion and recommendations, it is my view that times of hardship or emergency reflect the true nature of states within the liberalized trading system that we operate today. When we talk about liberalized economy, we still have to understand the fact that states are inherently protectionist at heart because they must satisfy their domestic needs before looking outwards. Therefore, when it is a crunch time, states will turn back to being protectionist. The second point that I like to highlight is that a domestic economy needs to be capable of managing, even if global demand and supply proves to be inconsistent. Therefore, there are certain sectors that it is important to cultivate and manage in this country without depending on imports for some of them. We have seen that import restrictions and import substitution are taking place. When these are not part of a long-term and properly thought-out plan, they are not correctly the way to go. Import restrictions will impact other sectors of the economy because the economy nowadays is also highly interdependent, and even in a single trade, that particular trade is interdependent on several other factors and supply and management chains to ensure that the final product or service is delivered satisfactorily. So the absence of one or two raw materials can bring an entire industry to its fall. Import substitution has been seen even in the 50s and 60s during the closed economic times of that era. And unless it is part of a well thought out plan, it is merely a waste of resources that will not see that particular industry growing. So it is not really suitable as an emergency response to a COVID-19 situation because these were not thought about in advance, certainly not prior to the pandemic. It is also important to note that long-term trade policy that does not vacillate and that does not unduly and abruptly keep changing track is essential for a country. We need to know today where we will be in 10, 15, 20 years and implement policies that are targeted towards taking us there. If not, such measures such as import restrictions and import substitution will only be cosmetic. And in the long run, they will actually have the potential to damage the local economy and prevent us from enjoying the full benefits of global trade in a liberalized world. That brings me to the end of my presentation. Thank you very much for your kind attention, and I would be happy to answer any questions that you have.
Thank you, Professor Nazima, for the wonderful thought-provoking video presentation. Now I leave to our panelists for their comment. Panelists, over to you.
Thank you, Professor Kamadin. I think that was a very timely presentation. Professor Kamadin, would you mind muting yourself while I'm speaking? It might just... Yeah? Okay, great. So I thought that was a very timely and really a cutting-edge presentation because you were taking into account the trade liberalization regime in the context of COVID-19. And I haven't seen anything on that topic. So congratulations on just taking on the topic. Also very clearly explained in terms of both the policy context as well as I think your legal arguments were very clear. You explained the rationale for the trading regime and how countries benefit from this, including Sri Lanka. And I think you then set out the sort of implications for Sri Lanka quite clearly. One thing I would perhaps suggest is to make Sri Lanka sort of more of a case study in the presentation. So I think you did say where Sri Lanka is justified in taking these import restrictions. And I'm sure your paper will do this, but if it does not, to actually just sort of set out very clearly what the exact justifications are for deviating from the standard regime rules. What are the permitted excuses or the permitted deviations, and then sort of considering in more detail whether Sri Lanka is justified in these import restrictions, because again, I'm not an expert in the area, but based on the actual full paper that you submitted earlier, I did note that you had mentioned that one of the permitted justifications was for a country to secure the health of its citizens. It could then deviate from the standard rules. I mean, here, arguably, to play devil's advocate, Sri Lanka is not really trying to protect the health of its citizens. It's really trying to manage its very precarious foreign exchange reserves, which is a problem because of the debt it has got into. So these are sort of, again, playing devil's advocate here, other countries may say it is a result of economic mismanagement and inadequate foreign exchange, and this is not therefore a permitted restriction. And then this may give credence to statements such as what the European Union made, criticizing Sri Lanka for its import restrictions, which was actually a very interesting development in itself, because previously the EU has sort of made these sort of criticisms in relation to GSP Plus on human rights grounds. Here, surprisingly, they sort of didn't mention that and moved only on to the trade ground. So looking at whether they really had a basis for doing that would be interesting. And I think secondly, in terms of a couple of other comments, in terms of the other geopolitical factors that are going on in relation to COVID-19, there was a recent resolution that Sri Lanka supported at the WTO to ensure access to COVID-19 medicines and vaccines, which would require some waiving of the WTO TRIPS agreement. Now, there are Western countries, I think, were quite, I don't think they've made a decision yet, I'm not sure, but were quite adamant that there shouldn't be any waiving of those, and were keen to protect their intellectual property rights. What is the interplay between your arguments and this TRIPS related resolution? Is it are sort of Western countries trying to force Sri Lanka to keep a very liberal trade regime, but also pay extra for vaccines and medicines? What's the equity basis in that? What's the sort of fairness argument in that? And interesting, I believe that China is not opposing the resolution, unlike the Western countries. So that's an interesting geopolitical context to think about. And then finally, I think just the sort of on the imports, and you mentioned obviously the export angle as well, the balance of payments. Are these import restrictions hurting Sri Lanka's ability to export? And, because you talked about the sort of supply chain aspects, I think so, just considering that aspect as well. I think, that's about all. Sort of on just a small point about the geopolitical context, I believe that both India and China are supporting the resolution that is being opposed by Western countries in the WTO. So that's another little twist to it. Thank you.
Thank you very much, Dr. Panditharatna. Justice Obesekara.
An absolutely excellent presentation, and as Dinusha said, it's very relevant. Probably nobody has spoken about it the way in detail, the way you have spoken about it. I also have a couple of issues overall. I remember 80s, 90s, in the 1980s, 1990s, the discussion was all about trade liberalization, the World Trade Organization coming in, going in for globalization, one world, one trade policy, so that there are no barriers, there are no restrictions. But in a situation such as what the entire world is facing, probably we never, if someone mentioned it 1 year ago, if we saw movie on this 1 year ago, we would never have believed that it could happen. But given the situation that the country is now in, which Dinesh explained, and especially at a time when the foreign reserves are low, our exports are not getting out, the foreign the income from Sri Lankans who are working abroad, that money is not coming in, and essentially with all our foreign earnings drying up, can Sri Lanka be compelled to keep up? I know we have Articles 20 and 21 of GATT, but quite apart from that, can Sri Lanka be faulted with if it is unable to keep up with the obligations it has undertaken in terms of the WTO? That's one concern that I had. Yeah, so I think we are all mindful. And then you did raise a very important point when we go for import restrictions, that can have an impact on the exports, because if you take garments, I think we get everything comes here and then we turn it out and send it out. So I'm not sure whether it's a complete ban on imports or whether the restriction is on luxuries, on luxury items, without touching those items which are required in order to generate export. But quite apart from that, I must again say that absolutely excellent presentation and very relevant. And this is something probably that we can learn from going forward, whether as a country, whether we should be 100% reliant on imports in respect of certain items, or whether we should have parallel production. One of the difficulties in doing that, I believe, is that the cost of production in Sri Lanka is higher than, say, for China, and then everybody prefers to go, or everybody prefers to import and then sell it and then the local producer gets knocked out. So those are some of the concerns I had, and once again, it's excellent. Thank you.
Thank you very much, sir. I'm grateful to both of you for your comments, and I do agree with the interplay between members of the WTO also. Though it is there are strict trade rules, there's also a lot of politics. There's also a certain leeway for arm twisting, and in that sense too, I think it's a concern that both of you had. What are the parameters within which Sri Lanka is able to operate, and that is why I brought in that the tension we're having with the EU. Because even if we do act within our rights, we are also beneficiaries of certain concessions, which are probably given at let's say the whim of the giver. So the EU would then say, if you are not willing to play by these things, we will not give you certain concessions. So that puts us in an extremely precarious position. Because, as both of you quite rightly pointed out, the foreign revenues are absolutely drying up because the Middle Eastern remittances are not there, because we don't export essential items. In terms of the ban being on luxury goods, yes, that is true. The point I'm trying to make is that sometimes within the classification of what is a luxury good, you may have an input, for example, something needed for the tourism sector, which may be classified as luxury, but which the sector thinks is essential. And then you could have, gaps there with certain items not coming in. But thank you so much for these. These are very valuable comments, and will help me to refine this paper as I go along with it. There was another question.
I have a question.
Doctor. Yeah. Yes.
Thank you very much for your excellent presentation. And I'm very happy that you bring the point that how we should manage this situation, either by saving the foreign currency, or are we going to manage this situation by earning more foreign currency? So I think that is the most important policy question before us. And in terms of question, I have one question, madam. If we're going to continue with these import restrictions, do you see any possibility of any country is going to challenge us under the WTO regime?
Yes, in a sense, if we, so what will happen is there will be impacts on already agreed obligations. So already agreed tariffs, already agreed import and export performance targets and so on will be affected. And then if there is a possible challenge, that is why I said the defense is already there in Article 20. But the point is that we are looking at this kind of, the violation, the nullification and the impairment, and then the move to dispute resolution in an extremely sterile environment. We then leave out the politics and the policies when we do that. So long before it goes there, Sri Lanka will probably be hit by some of those, the policy, the politics of the whole thing, because we are somehow vulnerable in that area also. So we can't afford to maybe even anger trading partners, because in some sectors we don't have too many competitors sending their products here. We may be having very few. So then we can't afford to really antagonize them in that sense. So we have to, it's like a balance, walking on a tightrope.
Well, just want to comment. The comment is that because earlier once you say that the India is restricting export of medicines, I was like all in scholars in international investment law, we were thinking about whether there's going to be a investment treaty arbitration. So once with the comments, I see the possibility that once we restrict the import, it will have a impact on our foreign investors who are going to export the things. So I think you can add this possibility of investment treaty arbitration against the country indirectly through the export restriction. I think if you can add this, it will be a perfect fit.
Yes, thank you, Dil. I hadn't thought of it from that view, but then that's what you're expert at. So thank you very much for that view.
Thank you.
Thank you, panelists. Thank you, Professor. Thank you, Dr. Devini. Now we will move. Yeah, anybody has any question?
Okay, question, Nazima.
Yes, Professor.
Already the country is by COVID-19 is down, and there is restrictions. Now these restrictions are not really boosting domestic industry.
Nazima, can you mute your microphone?
Sorry.
Yes, Professor, now you can.
Yeah, now the import restriction actually, practically those are not boosting the local economy. The items that they have restricted import are not locally available. For example, just say simple products of saffron or sugar or motor car, to go to the extreme. Now the motor car, there are paper articles that so many people are hit by the government's restriction on motor vehicles. Maybe even Trishow is not available now for anyone to buy. So do you think there is a policy lacking in Sri Lanka? But in the other way, that this antigen test, no restriction even against the medical council advice, they are allowing the import. So is there a lack of policy in our country, and that will take us to a worse situation?
Yes, madam, you are perfectly right, because what happens is it's a knee-jerk reaction. When you think you need to save foreign currency, you brand certain items as being luxury. But what is the perception of a luxury item? Now, we would quite rightly say that a three-wheeler is not a luxury item. But because of maybe the high duty that has to be paid, the fact that the government is very afraid of the leaking out of foreign revenue because its foreign reserves are very low, they need clamps down on these items. So even the selection of these items is sometimes extremely arbitrary, and that is what I said. In an economy where every sector is very isolated, you can do that. You can identify and say we are going to do certain things. But nowadays, so many sectors require so many raw materials and inputs from different places, and they sometimes also require certain finished products as their own raw materials. So within this setup, I do not think that kind of restriction will benefit, because even in the 30s and 40s of the previous century, the closing up of the economy by imposing high tariffs and the prevention of imports did have negative impacts on the economy, even when it was not as interdependent as this. So in terms of policy, I think Dr. Panditaratna may be tearing her hair out in despair because she's an expert on policy. We are very poor. We really don't have the long-term policies, and that's why we can't respond meaningfully when we are hit with a crisis like this. Thank you for that comment, that question.
Any other questions from panelists?
Yeah. Just a quick comment, additional comment as well. And I want to thank Justice Obesekera also for his comments, especially on remittances, which I not thought of, and that's very pertinent. Another particular aspect of the Sri Lankan context is is the port city development, right? Because I think you rightly pointed out, Professor Kamadeen, that COVID-19 has particularly affected the services sector. And you mentioned tourism as being particularly important for Sri Lanka. In terms of the future growth, the government is banking so much on the Port City project for FDI, and the Port City project is entirely services led. So perhaps just sort of considering the argument, taking tourism as a good example, and then of course remittances, other issues of the Sri Lankan context, but just in terms of the future perspective, maybe just looking a little bit about the prospects for the port city under this trade liberalization regime might be useful as well.
Okay, thank you very much. I'll do that.
Okay, thank you. Thank you everyone for such an excellent interactive discussion. Now I move on to the next presenter, Ms. Vitana Gay, lecturer from Department of Commercial Law. She will talk about the extent of existing legal framework relating to arbitration, which facilitates to solve intra-corporate disputes from different perspectives. Her topic is Beyond All or Nothing, an assessment of the arbitrability of intra-corporate disputes in Sri Lanka. Her pre-recorded video will be played now.
Good afternoon. After a couple of interesting presentations and discussion, I'm here to present my research findings on the topic of Beyond All or Nothing, an assessment of the arbitrability of intra-corporate disputes in Sri Lanka. If I am to just briefly give an outline of my presentation, in this presentation I will first focus on the overview of the background in which I formulated this research paper. Then I will look at the definitions for intra-corporate disputes, and as this analysis of this paper is done in three perspectives, namely statutory, judicial and doctrinal, I will deal with the theoretical debate and the arguments for and against in this analysis part. In arriving at my recommendations, I looked at few comparative jurisdictions, and I will look at the positive factors of those jurisdictions and give my recommendations to Sri Lanka. Moving to the background of this research, as we all know, corporate disputes are generally complex and dynamic in nature. Even in this Industry 4.0 era, international commercial transactions are also subject to novel arrangements due to digitization in the contemporary world. Litigation is recorded to be the old fashion when it comes to these commercial dispute resolution. And now there's a move towards alternative dispute resolution methods that can effectively address the concerns of the commercial world. As we know, experience in referring intra-corporate disputes litigation has been bit bitter due to several reasons like law delays, enforcement issues, erosion of corporate repute and confidentiality through adverse publicity and inefficiency. Referring corporate disputes into litigation has been the preferred method in Sri Lanka, and even in very few instances where they were referred to arbitration, the attitude of the court has not been pro-arbitration, and there has not been a positive response from the judiciary. However, it is evident that there has been a debate as to the arbitrability of these intra-corporate disputes. And in certain jurisdictions like USA, Germany, Philippines, Turkey and Singapore, they have effectively utilized arbitration to solve intra-corporate disputes. And these jurisdictions have moved from all or nothing approach and beyond in giving their decisions. And even in countries like India, they have concerns of introducing mandatory arbitration clauses to corporate legislations. Therefore, this paper intends to arrive at recommendations based on an assessment as to whether and to what extent that the existing legal framework on arbitration in Sri Lanka is being effectively utilized and how it can be more effectively utilized as a platform in solving commercial disputes. Looking at the definition of intracorporate dispute, it can be noted that there's no single definition. However, different international forums and jurisdictions have come up with their own. So in Philippines, which is one of the mostly spoken jurisprudence, due to the recent changes that they brought in facilitating intracorporate dispute arbitration, they have defined intracorporate disputes using two tests, namely the relationship test and the nature of controversy test. As it is explained in the Union Glass and Container Corporation case, this relationship test focuses more on the relationship of the parties involved into this dispute. However, the nature of controversy test not only focuses about the relationship but also about the controversy itself. The controversy must not only be rooted in the existence of an intracorporate relationship, but it must also be pertaining to enforcement of parties' correlative rights and obligation under the corporate legislation. Looking at my research problem in a statutory perspective, I here examine the arbitrability of intracorporate disputes under the existing legal framework for arbitration in Sri Lanka. As we know, the existing legal framework for arbitration is based on the Arbitration Act number 11 of 1995. Arbitrability is known as one of the cardinal principles of this Act, and the Act sets out its scope in a clear manner. According to Article 4 of the Act, matters contrary to public policy and matters that are not capable of determination by arbitration are not arbitrable. In Section 5, which is known as the ouster clause, it has created not a total ouster but a partial ouster, where it says when a party to an arbitration agreement institute legal proceedings in a court against another party to such agreement, the court shall have no jurisdiction to hear or determine such a matter if the other party objects to the court's exercising jurisdiction in respect of such matter. However, there are certain exemptions emphasized in case law to this Section 5. One such exemption is the oppression and mismanagement under Section 224 and 225 of the Companies Act. So if a matter on oppression and mismanagement having an arbitration agreement is referred to court, the court will have the jurisdiction to hear such matter despite of the provision in Section 5. However, it can be well noted that there is no bar to refer an intracorporate dispute to arbitration under the existing legal framework. And also, the Act does not have any specific definition or reference to intracorporate dispute arbitration as well. When we look at the corporate legislations in Sri Lanka, in Companies Act of number 7 of 2007, the only alternative dispute settlement mechanism mentioned is the corporate dispute boards, which is not in an effective status too. Looking at the very limited case law in ascertaining the judicial response towards arbitrability of intracorporate dispute, I would like to draw your attention to the decision on Aitken Spence case. This case demonstrated rich doctrinal explanation on this subject matter. This case was relating to a matter that came under Section 210 and 211 of the All Companies Act. In the decision, Justice L.K. Vimalachandra clearly denotes that Section 210 and 211 intends to give the power to the court to provide a just and equitable settlement and enable the company to survive while preserving the rights of the affected shareholders. The decision in this case was based on this just and equitable argument. The court looked at the Indian jurisprudence and the court was of the attitude that only a court is vested with such a power to make an award based on just and equity, but not an arbitral tribunal. In my point of view, I also admit that argument. However, I think that this just and equitable argument cannot be brought in all instances of intracorporate disputes, but only in limited instances like oppression and mismanagement. However, in the Binod Tyres case, Justice Salim Marsoof acknowledges the dynamism in these interrelated concepts, and he also says that arbitrability is something that keeps changing from time to time and from country to country. So this is a very positive approach in looking at this arbitrability of intracorporate disputes as well, which can bring in a lot of change in the future as well. In my comparative study, I looked at Professor Joseph Lee's argument. Joseph Lee believes that litigation is not the favored enforcement method of corporate governance for listed companies in UK. UK as a jurisdiction has showcased poor arbitration approach in these type of intracorporate disputes. Fulham Football Club case is a very significant judgment which focused on the arbitrability of a shareholder's unfair prejudice claim brought under Section 994 of the Companies Act 2006. This decision has been a lighthouse to the courts in deciding corporate matters coupled with arbitration with judicial activism. This decision embarked on the will of the contracting parties to choose the option to avoid domestic courts and refer a matter to an arbitration tribunal respecting their party autonomy. In the post-Fulham period, Exeter City Association Football Club Limited case is referred for the all-or-nothing approach to the arbitrability of statutory minority oppression claims. In the Fulham Football Club approach, it has been followed in number of other jurisdictions, like in Singapore in the Tomelguen Holdings case, in British Virginia Islands, and in Hong Kong, and in other jurisdictions as well. In US, intra-corporate dispute arbitration has been in practice for many years in resolving disputes including shareholder claims for breach of fiduciary duty against the company directors in a takeover bid both in non-listed and listed companies. Recently, in 2019, Philippines has brought changes to its Republic Act, introducing Section 181, and it has enabled the companies to refer intra-corporate disputes into arbitration. In my doctoral study, I looked at the theoretical debate on intra-corporate dispute arbitration and the application of it into Sri Lanka. According to Coffey, arbitration may be an adequate substitute for litigation in certain cases, but only consideration has to be whether arbitration is being used as a way of evading or undermining a policy being persuaded by the framework of company law rules. Arbitration of intracorporate dispute can also be identified as a useful tool for institutional investors who make long-term equity investment in emerging markets in general. So this could be a positive factor to attract foreign investors who wishes to have portfolio investment and also to have the option for effective dispute resolution. According to strong arguments by Joseph Lee, one of the most outstanding features in ICD arbitration is promotion of shareholder-centered corporate governance. We know that Sri Lanka records to have very less shareholder activism, and always the majority rule plays an active role in decision-making process. With this backdrop, arbitration can be identified as a way to rectify the wrong through a governance settlement system which does not contain unnecessary publicity which is not favored by the commercial community. When the domestic regime is concerned, Sri Lanka is a country where we have some sort of expensive corporate litigation. So, arbitration of intra-corporate disputes can be a very good tool to enhance shareholder activism, and it would lead to transparent and effective functioning of the corporates as well. However, we also should admit that we don't have a state-owned or state-funded arbitration center. So in that case, it could be little difficult for the small investors or the small enterprises to opt for this option. And also there's a strong argument that arbitration may prevent case flows into litigation. However, there can be a downfall of development of company law through judge-made law as well. When Sri Lanka is concerned, we have very limited case laws which has added a doctrinal value to the canvas of company law in Sri Lanka. So in that sense, I don't see that arbitration could be less advantageous when it comes to intra-corporate dispute settlement. Moving to my recommendations, as I observe, company constitution is one of the best paths that can provide a solution to this issue. So the drafting of company constitution and contract should be done in a very careful manner that it define these type of disputes and the parties and the particular power given to the tribunals. As Joseph Lee also suggests to UK, I also see that the Sri Lankan arbitration and corporate law regime could also develop supplementary rules, like an inclusion of a section to the model articles of association that can be incorporated into the company constitution. So it would provide legal certainty to the proceedings and also ensure the enforceability of the award. And I also suggest Securities and Exchange Commission and the arbitral tribunals should also design their own rules on multi-party arbitration and representative suits for securities law disputes. And this move towards arbitration of intracorporate disputes is not possible only through legal framework designed for it. So the judges and arbitrators' attitude and the arbitration culture should also be broadened towards accepting the fact that intracorporate disputes are arbitrable and the existing legal framework can be utilized effectively for that. Thank you for your attention. I look forward to hearing the comments from the expert panel and the participants, which will be very helpful for me to develop this paper into a publishable quality. Thank you.
Thank you very much, Ms. Vitanage. I'm going to take over from Shamila for a little and invite the panelists to give their observations.
Well, thank you very much, Ms. Vitanage, for your presentation. I learned a lot from it. Certainly, I think it was convincing as to why the private sector here needs to be more focused on arbitration as opposed to litigation. And you set out quite clearly the benefits of this alternative method of dispute resolution. You also quite admirably set out the clear policy goals that connect to your legal arguments, including the policy goal of Sri Lanka becoming a hub, including attracting more FDI. I don't have any specific comments on the legal aspects. I guess one question I had is, it seems like Sri Lanka has been talking about improving its arbitration regime for many, many years, but that it never sort of really takes off. And perhaps you could include an analysis of why that has been the case, because arbitration is always at the forefront, it seems, of law reform goals, but doesn't really move, at least to my knowledge, and I might be wrong, doesn't really sort of move at the speed that one would expect from having that consistent goal. One aspect you may want to consider is, especially in relation to developing arbitration in order to attract FDI, is whether the current sort of framework of resources in Sri Lanka is adequate to build that arbitration center that you are advocating. And specifically, I'm going to raise a sensitive point of, whether Sri Lanka really needs to introduce foreign law firms into Sri Lanka. You mentioned Hong Kong, Singapore, there's also Dubai. These are the big centers for arbitration in the region. What do they have in common? They all have foreign law firms. Singapore, for example, didn't do this straight away, did it in a very step-by-step way, having first a few law firms approved after very careful analysis, then the next set of a few law firms were approved. So they brought them in very gradually, being mindful of the local lawyer sentiments against such introduction, but also realizing that they have to sort of internationalize and standardize in order to meet these goals of becoming a dispute resolution center generally, and having FDI. And having been in Hong Kong for many years, I can say, I think in Hong Kong that there may have been sort of initial trepidation about having foreign law firms, but if you ask any local lawyer in Hong Kong now whether it's a good thing or a bad thing, they would say that they have benefited from having foreign law firms because they have had access to so many more new clients, because of the partnerships that ensue between local and foreign law firms. So the new business that comes in and the development of standards, including an arbitration, has been fundamental to developing those broad policy goals of becoming a hub and an arbitration center. So I sort of invite you to maybe just consider whether sort of the gradual introduction of foreign lawyers would help to advance the particular goals that you are speaking about in your very very good presentation.
Thank you, Dr. Dinosha, for those valuable comments, and specifically the comment on the foreign introduction of foreign law firms to Sri Lanka, which I think would create an interesting debate on this issue. So I will think about it and develop my paper. Thank you. Justice Obesekara, would you like to make some comments now?
Yes. As Dinusha said, it's an excellent paper, Ms. Vithanage. Arbitration is something that I've advocated in the last 10 to 12 years. But as was mentioned by Dinusha, one of the concerns that arbitration in Sri Lanka is faced with is the speed. And whether a dispute once is presented, whether the arbitrators are able to dispose of the matter as expeditiously as is intended. Because arbitration has always been offered as an alternative method of dispute resolution on the basis that it's going to be quicker than going to court. Going to court requires maybe 2 or 3 tiers of litigation, whereas arbitration, you go to arbitration, and then when the matter comes to the High Court, if there's a challenge, the challenge is on very limited grounds as opposed to traditional litigation. Ms. Vithanage, you're raising a very important point with regard to intra-company disputes. That's the focus of your presentation. When you were making your presentation, I was mindful of the fact that our law as it stands today, and I believe that captures the essence of arbitration, is that the agreement to arbitrate should be consensual. That it's both parties must consent to go for arbitration. That's the party autonomy that we speak of. And I had noted it down to take up with you how do we incorporate the agreement to arbitrate. But then you referred to, I believe, a Philippines case and said that can be done by way of an appropriate clause to the articles. In fact, that form part of your recommendation as well. Also, if it's a dispute between the shareholders, then of course, if the shareholders have a separate shareholder agreement between them, then that's another way where you can incorporate arbitration. It's certainly a way forward. And as we know, the Commercial High Court in Sri Lanka is the court that has jurisdiction in respect of any matters arising from the Companies Act number 7 of 2007. And then there's one right of appeal to the Supreme Court. The one concern I have with having intra-company disputes going for arbitration, though, Ms. Vithanage, is that we see a lot of, especially in the case of oppression and mismanagement, in the section 211, 210, 211 applications, a lot of interim orders being obtained. So the luxury of going to court is that you are able to present your papers or present your petition fairly quickly, on an urgent basis rather, and you can have it supported fairly quickly, and you can, if the judge is satisfied that there's a prima facie case, you can obtain an interim order preventing the oppression and the mismanagement that is complained of. Now, the difficulty in going for arbitration, as you know, is that you have to, if the arbitration clause contemplates a panel of 3 arbitrators, then you have to get your arbitrators in place, and it is only once the arbitrators are in place that you can get an interim order. There are solutions to that also. I believe you are aware of that, in that you can go to the High Court and ask for an interim order until such time that the arbitrator is constituted. You might recall that in Singapore, they have introduced a mechanism of what we call emergency arbitrations. So if you are thinking of intra-company disputes, you might like to consider an emergency arbitrator as well. Of course, that requires a proper center to be in place. Like in Singapore, you have the Singapore International Arbitration Center, which under their rules, there's provision for emergency arbitrators where they manage and administer the whole arbitration, where you can get relief in less than, maybe even in certain cases, in 24 to 48 hours. That's how quick it is. So that's something that you will have to be mindful of. Dinusha also spoke about the arbitration center. Sri Lanka we have 2 arbitration centers at the moment, and it has the ICLP and the Sri Lanka National Arbitration Center, and the government did establish another arbitration center. Well, not a center. They established a they didn't set up any rules, but they did set up the infrastructure. It was launched somewhere in 2016 or 2017, but unfortunately it did not get off the ground. So there's a lot of groundwork that needs to be done if we are trying to attract companies outside Sri Lanka to come in for arbitration in Sri Lanka. So subject to that, I think your ideas are excellent, and probably this is something that maybe you should explore with companies, whether they feel that, what are their concerns with the present legal regime, and with the arbitration on an expedited basis with the provision for emergency arbitrations would be a better choice. So those are some comments I thought that I'll share with you. Thank you.
Thank you, sir.
Shamila, can I say something?
Yes, of course, madam.
Sorry, Nazima.
No, that's okay. Yes, please go ahead.
Yeah, now rather than a question, it's a brief comment, Pramoda. Very good presentation. I really enjoyed. Now the definition for intra-corporate dispute will have to be settled. If it is between the company and the shareholder, yes, as you said, it can be a clause in the constitution. But if it is between the company and general public in the society, then of course the constitution clause will not work. Or the other way is the shareholder agreement. But the reality is the mediation that we have in place now is not working. That is the company's dispute board that has been properly established. The members are appointed. But because two parties have to go before the mediation board, and that has never happened so far. Within these 13 years of company law, that has not happened. That's the reality. So the mentality of these corporates and the shareholders are they are willing to spend money to fight a case in the commercial high court for mostly on mismanagement operation cases. So we may have to look at that exemption under the Arbitration Act. Why these two are exempted? Is it because of the interim order power that the court is given, or for something else? The objective behind this Section 5 arbitration exemption to be looked at. If that is removed, then maybe the parties may go for arbitration. So when that is there, that is actually a bar for anyone to go for arbitration for mismanagement and operation. And also actually this will serve the purpose. Many companies have actually suffered because of this intra-dispute between the shareholders and them. Lot of money is spent and time is spent. Now we teach the students, now why not make use of that for some other business purposes. Now even now COVID situation, not that the cases are facing low number of cases, no, enough number of cases are still there. So it is the mentality of the corporations that they are prepared to spend money. They are not towards any alternate dispute methods. Good, Pramoda, I'm happy. Right. Congratulations.
Thank you for the comment, madam. If there are no further comments, let us move on to, we have saved the best for the last, the final presentation of the day. That is by Dr. Dilini Pathirana. So we have two Dr. D. Pathiranas in our department. And Dilini is, she has done her doctoral studies in international investment law. And her presentation is titled Once Bitten, Twice Shy, the Significance of Sensitizing Sri Lankan Judiciary about the country's international investment obligations. So may I invite her to make her presentation now. Dilini, is it the pre-recorded presentation?
Yes, Nazima.
Okay, thank you. Okay.
Good afternoon, everyone. It's my pleasure to be here today and present my ongoing research paper at the annual research symposium of the Faculty of Law. As you can see, this research is basically about Sri Lanka's international investment obligations. I do believe that Sri Lanka should seriously consider her international investment obligations, and thus The conclusion of this paper further supports my argument, which has been developing since 2015, that Sri Lanka should reconsider her approach towards the investment treaty regime. With this explanation, we'll move to the detail of this presentation. To begin with, I carefully observed that several high-profile development projects in Sri Lanka involved in or driven by foreign entities were challenged on several grounds, particularly including their incompatibility with fundamental rights as contained in the 1978 Constitution. For the context, the Colombo Port City project, one of the biggest foreign direct investment projects taking place in the country, was challenged in a fundamental rights petition which sought an order to cease the project. True that this petition was terminated by the Supreme Court, yet I have a question for you. Let's assume that the Supreme Court sees the project as a remedy granted under its fundamental rights jurisdiction. If so, if you were the foreign investor who affected by this judgment, what would you do after sinking $1.4 billion into the Indian Ocean with the purpose of reclaiming the sea to build an ultramodern city? Let's take another example. Imagine that you were the foreign investor involved in the fundamental right petition brought against the Chunnakam power plant project in order to seize it. True that the Supreme Court rejected to seize the operation of the project, but what if the court ordered so? As the affected foreign investor by such a judgment, what would you do? In my opinion, firstly, these questions brought largely forgotten aspect of such lawsuit into the fore, that is to say, their economic impacts on foreign entities who directly or indirectly subjected Sri Lanka's fundamental right jurisdiction. As a researcher in international investment law, such concerns driven me to further consider them in terms of international treaty jurisprudence. So, let's move to my research questions. So I unpacked my main research question into 3 sub-questions. Firstly, could aggrieved foreign entities challenge such legal proceedings as a violation of investment treaty protection granted to them by Sri Lanka's investment treaties, largely bilateral investment treaties? If so, what are the possible legal grounds that can be invoked by such foreign investors? And finally, have foreign investors challenged the administration of justice in Sri Lankan courts as a violation of investment treaty protection afforded to them under the country's bilateral investment treaties? These were the research questions that I wanted to answer by conducting this research. Perhaps you may not agree with me why we should consider these type of questions, as Sri Lanka's fundamental right mechanism is truly an effective means to safeguard citizens' fundamental rights and to ensure rule of law in the country. Indeed, one could argue that the economic impacts of fundamental right petitions on foreign investors should receive less emphasis compared to the protection of constitutionally guaranteed fundamental rights and the protection of Sri Lanka's natural as well as national resources against any misuse by the executive. I totally agree with these arguments and do appreciate the approach taken by the Sri Lankan Supreme Court in this respect. However, in my opinion, no one can ignore the clear message sent by the majority award in the Deutsche Bank case, which decided against the Sri Lankan government by an investment tribunal constituted under the German-Sri Lanka Bilateral Investment Treaty. So let's discuss this case in brief. This case involves a complex set of facts. Perhaps you may know, this arbitration, inter alia, confronted an interim order issued by the Supreme Court in the Fundamental Rights Petition, which challenged the hedging agreements entered into between Ceylon Petroleum Corporation and 5 other commercial banks. The claimant investor argued that the interim order issued by the Supreme Court suspended all the payments under the disputed hedging agreements, violated investment treaty protection afforded to the Deutsche Bank under the Sri Lanka-German Bilateral Investment Treaty. The majority of the tribunal agreed with the claimant investor as they found that there was a lack of due process and the disputed interim order had deprived the claimant investor of his rights under his investment in a manner which constituted an expropriation, of course, a judicial expropriation. The most important fact was Sri Lanka was held responsible by the majority of the tribunal, partly for its judicial actions, with the claimant investor being awarded $60 million compensation. Therefore, I consider the majority award of the Deutsche Bank as a clear message sent to the Sri Lankan judiciary that its measures could trigger state responsibility if they amount to a violation of the country's international investment obligations. The award, moreover, provided me with affirmative answers to most of my research questions mentioned above. Further readings on this issue demonstrated to me that there are several legal grounds on which any aggrieved foreign investor can rely if they wish to challenge the administration of justice in the host state courts as a violation of investment treaty protection afforded to them. I have displayed such identified legal grounds here, but unfortunately time does not allow me to explain all of them. However, I found that several legal grounds are available for foreign investors who want to make Sri Lanka liable under international law for violating the country's international investment obligation if such investors believe that they were mistreated by the Sri Lankan judiciary procedurally as well as substantively. Sri Lanka's current bilateral investment treaties in particular provides foreign investors with effective international legal protection against adverse judicial measures of the host state courts while putting the Sri Lankan judiciary on alert. Therefore, with due respect, I infer the necessity of Sri Lankan judiciary taking the country's investment treaty obligations seriously in order to avoid instances similar to Deutsche Bank case in the future. I argue that it's essential due to two main reasons. Firstly, as I just mentioned, Sri Lanka's investment treaties provide foreign investors with effective legal protection under international law against adverse judicial measures of the host state courts. Secondly, the country's affect courts is being increasingly called upon to make decisions on proposed or ongoing foreign investment projects incidental to fundamental right petitions, which would have far-reaching implications on foreign investors. Finally, I conclude that time has approached for Sri Lanka to consider her approach towards investment treaties in general. As a part of this policy response, the country should specifically address the issue of reviewing administration of justice in Sri Lankan courts under the mandate of country's bilateral investment treaties after being ordered to pay $60 million compensation partly for the country's judicial actions taken while adjudicating a fundamental right petition. This recalls me as saying, to simply frame my argument in this research paper, once bitten, twice shy. Thank you.
Thank you very much for your presentation, Dr. Dini. I would like to invite the panelists to make their comments now.
Thank you very much, Dr. Patrana. I've benefited in the past from your excellent research in this area, and this presentation was also very instructive. I think your arguments were very clearly made, and that it's something that the Sri Lankan judiciary would have to bear in mind. I'm sure Justice Alvesekar has much more detailed analysis to offer on that from a judicial perspective. From my perspective, I would just ask the question about the current framework of the bilateral investment treaties, given that most of them were signed and ratified some time ago, whether you feel that they are responsive to Sri Lanka's current needs in areas such as environmental protection, so due process, transparency issues. Those are sort of the modern substantive developments in investment treaties. And perhaps when Sri Lankan courts rule against or make sort of decisions that put us at risk of the Deutsche Bank situation, they may be considering sort of some of those broader issues. So that's just sort of a bigger question to ask about whether our current regime of bilateral investment treaties is adequate. Something to also consider in that line is, Sri Lanka's commitment to the SDGs, right? The Sustainable Development Goals. So a couple of the phrases that you used in your abstract, I think you said the line of reasoning developed by the Sri Lankan judiciary in these cases exhibits its firm attitude that the country's public property should be exploited for the benefit of the entirety of the citizenry. That was a quote from your abstract. When I saw that quote, I thought, well, that kind of line of thinking actually could be compatible with the Sustainable Development Goals. I don't know if there's any international jurisprudence on that about how the previous Millennium Development Goals and now current Sustainable Development Goals fit into these investment decisions. Maybe some of the exit jurisprudence might have some things to say on it, for example. So those were just some brief comments. But
okay,
congratulations on a good paper.
Thank you very much for your kind response. So with respect to first one, that's what I said, that since 2015, with the publication of my first article as a PhD candidate, I keep arguing that Sri Lanka should reconsider her approach toward the bilateral investment treaties, because the existing treaty regime is concluded between 1980s. After the most of them were concluded in 1980s. So those are pro-investor treaties. It means that we give the maximum protection for the foreign investors in order to, or we believe that the more protection we give, the more investment we will receive. So this is the grand bargain behind this old generation bilateral investment treaty. So we adopt this, and we believe that this is something we need. And not only Sri Lanka, all the developing countries were in the opinion that we should have this kind of international obligations. And especially the most important thing is these bilateral investment treaties very clearly allow foreign investors to bypass the national court system and directly recourse to international arbitration, which the mechanism used by the Deutsche Bank in this arbitration as well. So the first question, I totally deny the fact that Sri Lanka's bilateral investment treaty is going to address the current need. Especially then I can link with to your second question about sustainable development goals. So here I think I'm developing my paper, and what I have presented is a very simple argument. I see through the analysis of cases, it's not about Chunakam case. These cases, line of reasoning were beginning from the Bulankulama case, Sri Lanka Slick case, Insurance Corporation case, and the Water's Edge case. All these cases involve foreign investors, and our court nicely developed a line of reasoning saying that the public property should be exploited for the benefit of entire citizens in align with the sustainable development. So it is a very highly appreciated approach. But in practice, I found a disparity between the practice of executive and the ideology of the judiciary. Judiciary want to make everything to ensure that our resources used to the sustainable development, but it is not the practice with respect to the executive who dealing with foreign investors. So there is a discrepancy between what is the judicial ideology and the practice of the executive when are dealing with the foreign investors. So this discrepancy in some jurisdictions, these kind of discrepancies has led foreign investors to initiate arbitration against the host state, saying that they were trapped between two policy perspective of the host state, executive, administrative, and the courts, and then they couldn't continue with the project as they agreed. So they challenged these kind of situations in arbitration, saying that this discrepancy, we got trapped into that. This has violated our investment treaty protection. So in that sense, I'm developing this argument saying that our courts want to ensure that foreign investments should be used for the sustainable development, but it's not the practice of executive in the most observed cases.
Could I now invite Justice Obesekara to make his comments?
Yes. Dr. Pathirana, excellent presentation. Your explanation that you gave now is really good.
Thank you.
So there's I think a lot of work that you plan to do. The concern, there are two matters that I'll just address. The first is with regard to the port city. The port city, there were two cases, as you said, that were filed, one in the Supreme Court, one in the Court of Appeal. Prior to becoming a judge, while I was in the Attorney General's Department, I was involved in that case. The concern of the petitioner in that case was with regard to whether all the provisions of the National Environmental Act had been complied with. The position that we took on behalf of the government at that time was that all the provisions had been followed. As you probably are aware, the National Environmental Act has provisions for a public hearing. The documents are published well in time. The public is made aware that there is a project like this. Here are the studies. Here are the environmental impact assessments. All those procedures had been followed. So in that particular case, that was a concern. Then Dinusha did read a passage from your abstract or from your full article, I believe, that you shared with us. I think you took it from the case, the Colombo case of Justice Amarasinghe. There also, it was an Australian investor, but the court was concerned that there was lack of sustainable development, as you and Dinusha both referred to. So this is an interesting area. And like what I said with the first topic, when it came to the first paper on the symposium about confiscation by way of civil as well as criminal sanctions, I think here also it's a question of balancing the interest of all parties. And so courts, then will be mindful of that. So I thought just some comments with you on that. Thank you.
Thank you very much, sir.
Are there any further questions or comments? No, in that case, may I have your permission to wrap up the session? Our regular head of department, Mr. Menaka, was unable to connect. I think he had some connection issues. So as the acting head of the department, I would like to propose the vote of thanks. For the second session, we had Honorable Justice Arjun Obesekara and Dr. Dinusha Panditaratne joining us as panelists. I'm most grateful to them for reading the abstracts and the full papers and for not only asking the questions, but also giving the insights and suggestions for how these papers can be taken forward and developed. As you know, now transforming ourselves from teachers to researchers has become a high priority because this was observed from some time back that we had to become a more research-oriented university. And this is what will then keep us relevant if we are able to engage in the kind of cutting-edge research that we see happening in other research institutions and universities across the world. Our department is fortunate, even though it is a small department, it has all subject specialization. So we have seen an interesting array of research from talking about incentivizing research to artificial intelligence, the use of drone technology, talking about international investment, dispute resolution, corporate law, and investment law, trade law, and all of that. We've seen papers across a wide spectrum of subjects that we teach and which we feel are extremely relevant in today's society. So I would like to encourage all my colleagues to keep on with their research and to convert these into good publishable full papers. I would also like to mention that this year's conference chair for the Law Faculty Symposium is Professor Shanti Segarajasingham from our own department. I would like to congratulate her for having accepted to be the conference chair and for seeing us through very difficult times, making hard decisions whether we were going to conduct this face-to-face or online, and then for putting in place all the extra measures that we had to take to ensure that we had a smooth conference. I'm glad for her foresight in asking us to pre-record our presentations because some of us did have technical issues, and I am happy to report that our technical sessions have functioned. Even despite these issues being prevalent, we have managed to overcome them and have a very successful technical session. I'm also grateful to those invitees who participated and those other participants, our undergraduate and our postgraduate students who participated, and I hope all of you have had a productive and fruitful afternoon spent with us as we have deliberated on some of our research that we have been doing. So on that note, I would also like to thank Dr. Shamila Dawood. She undertook the role of being moderator, which was not easy because it also meant she had to tie up a lot of logistical ends. I would like to thank Dr. Dilin for being in charge of the abstracts, and everyone else in our department who came forward and volunteered and undertook so many different roles without having to be asked, and who have all delivered to make sure that our technical sessions were extremely successful. And now I can only wish that your papers will reach the standards that the panelists and everyone else has given you the instruction to take it forward to. So on that note, I would like to thank all of you for having joined us and wish you a very pleasant afternoon. Thank you.
Nazima, could we take a photograph?
Yes, madam, I think that's a good idea. Shamila, do you think you can, do you know how to get that done? Can
yes.
Stay on for a little while?
Yeah, please on your video.
Where is Indira? Is she?
I'm here. Wait, I'm trying to. Yes.
Sampath sir?
Yeah.
And where are others? Yeah, here. Excuse me.
Yes.
Screen shot. You can. Yes. Okay. There are two profiles. They haven't switched on their videos.
Samangi, where are you? And
madam, my camera is not working, madam.
Okay.
Something happened.
So basically, we need to bring down the video camera a little bit so we can't see your full profile.
Sampath's screen is close, I think. Sampath's face also for me like cut top and bottom.
Right.
You can sit back. Yes, that's right.
Yeah.
Yeah. Still not video. Wait. Don't take. I think that Arjuna's face is not.
Arjuna's face is not there, no?
So we can't see you, sir. Ah, right. Okay. Yes. Okay. 1, 2, 3. Done. Yes, thank you so much. Okay, thank you.
Thank you, everyone.
Thank you so much, madam.
Congratulations to all. Thank you.
Thank you.
Okay.
Shamila.
Yes. Who is that?
Darshika.
You want to take a photograph?
No. Done. I will send the photograph.
Really? Everybody is there?
I will.
You said it to, yeah. Okay. So, what else?
Now we want the refreshments, so not so.
I had my